One live.
Thank you. Recognizing a quorum of commissioners, I call the April 16th, 2026 meeting of the Cannabis Control Commission to order. This meeting is being held hybrid pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioners Benedon, Stebbins, Roy, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a full agenda today that I will generally summarize. We will not start with opening comments from commissioners. We will actually take that at the end of the meeting. I am going to be moving some of the agenda items around today because we have quite a bit of items to take care of, especially with 420 coming up on Monday. So some people may be looking earlier in our agenda and they will be pushed to the end. We will vote on meeting minutes. We will proceed to staff licensing recommendations, and then we will take up 3 change of ownership recommendations, 17 license renewal recommendations, 4 final license recommendations, and 6 provisional license recommendation. And then we have 10 items in the commission discussion and votes. And then at the end, we will have the executive director's report, which will include the presentation or any information about the public information on 420. So with that, we will begin with the approval of the minutes. I'm looking for a motion to approve the minutes for March 4th, 2026. Commissioner Roy, do I hear a motion to approve those minutes?
So
Do I hear a second, Commissioner Stebbins?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Roy,
aye.
Commissioner Benedon,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. They are approved unanimously. I will also, Commissioner Roy, I will entertain a motion to approve the March 12th, 2026 meeting minutes. Do I hear that motion?
So
Do I hear a second, Commissioner Stebbins?
Second.
I will call the roll. Commissioner Benedon,
aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. They pass unanimously. We will now move to licensing recommendations, and I am told that Jamie Wakefield is presenting on behalf of, hey, Jamie, on behalf of licensing today. Again, you probably weren't ready to come up here this fast, but we're trying to make sure that we get to some important votes early on, so we appreciate that. Okay, so we start with Arrow Cultivate.
Yes, thank you. There are 3 change of ownership applications for consideration today. The first licensee is Arrow Cultivate LLC. They're seeking a change of ownership and control over 1 adult use license and are requesting to add 2 individuals. Additional information is contained within the executive summary for the commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Are there any questions from FL commissioners? Hearing and seeing none, I will entertain a motion. Commissioner Benedon, will you move to approve the recommendation of change of ownership for Arrow Cultivate?
So moved.
Commissioner Stebbins, will you second that?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. It passes unanimously. New England Regional Dispensary LLC.
The licensee here is New England Regional Dispensary LLC. They are seeking a change of ownership and control over 1 adult use license and are requesting to add 3 individuals and 3 entities. Additional information is contained within the executive summary for the commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Do I have any questions or comments from my fellow commissioners? Hearing and seeing none, Commissioner Roy, will you move to approve the change of ownership of New England Regional Dispensary?
So moved.
You second that, Commissioner Stebbins.
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. Passes unanimously. On to Phytopia Incorporated.
Itopia Incorporated is seeking a change of ownership and control over 1 medical marijuana treatment center license and are requesting to add 2 individuals and 1 entity. Additional information is contained within the executive summary for the commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you so much. We will, there is one issue, and I would call up our general counsel because we did have a question that was raised by the attorneys from Ignited Culture. We will include that in today's renewal license, but I would like our general counsel to explain, what is happening. Attorneys have raised some questions about paperwork and ownership and whether or not there have been some inaccurate filings that have been made. I don't want to be too specific, but I'm not asking you to testify. I'm just saying, just broadly, there are some questions about paperwork that was submitted. We are inclined to allow this renewal to go through. There is an appeal process, but again, we'll ask the general counsel to explain this.
Good morning, Madam Chair, Commissioners. Thank you for recognizing me, Madam Chair. I just to let you know, I just was recently brought into this matter, so just getting caught up to speed. But my understanding is that there is a civil suit pending regarding some ownership disputes that are going on between some of the existing owners of this business. I do not perceive that to be an impediment to going forward with the determination on the license renewal here today. And the civil case will proceed on its own, and obviously the commission will abide by whatever ruling comes out of that case.
Have you had an opportunity to speak directly with the relevant parties?
Well, I spoke with counsel who's here in the room today very, very briefly about this, so got some sort of highlights, but to the extent of it.
Okay, thank you very much. Okay, Commissioner Roy.
Thank you, Chair. To the Chair, to the General Counsel. Based on certain allegations made, I know it's going through the court of competent jurisdiction, but is the commission looking into any of these matters?
I would have to defer to my colleagues in licensing to ask them, but I think we would, again, the packet is before you. All the relevant information for your consideration on the renewal is in your packets. To the extent that other information would be considered, I defer to licensing on that. But as I said before, I don't think so. I don't think it's necessary, but
I think that'd be helpful. Again, we just want to make sure. It's my understanding that in the past that there has been at least one occasion that I've observed when there was some question about appropriateness of the transfer of equity ownership that did hold up a license. So I just want to make sure that we're on solid ground.
Yeah, so
Thanks.
in any such instances, licensing coordinates with the investigations team to look into matters further. So that's the due course of process.
But if there are any questions about who owns what, it's still okay for us to proceed.
Yes, typically in the course, that's been our process because, until the investigation concludes, we are not able to opine one way or another. So we wouldn't want to hold up any license progress without knowing the outcome of the investigation.
Madam Chair,
Thank you, Commissioner Wright.
just understanding our options. This license, if it's not renewed, will expire. Is that accurate?
Sorry, what?
If this license not renewed, will expire?
Yes,
By the board. Okay, and if we remanded it, that would jeopardize the license. That could force it into expiration too, correct? If we remanded this back.
Correct.
Well, yep.
Yep, okay. So just because there would be a renewal by the board doesn't mean that the commission ceases to do its due diligence into allegations. So two things can happen simultaneously. And a renewal doesn't jeopardize or cease an investigation.
No, you're correct. Yeah.
But if we've remanded it back, it could cause the licensee to expire, the license
Correct.
to expire.
I believe they expire in May. So yeah, they would expire in
They would expire. So to keep this license viable, this board has to renew, and then the commission and the enforcement team can do their investigation.
their due diligence, yes.
Okay,
Okay.
I just want to understand
Yeah.
the options.
Thank you very much. Thank you.
Welcome.
Okay, but it's well said. Thank you. So we'll move on with this. So anyway, we have, I will entertain a motion to approve the renewal licenses 1 through 17 as recommended by the staff. Do I hear that motion, Commissioner Bennett?
I don't know if you noticed, but it looks like council wants to speak, and I just wanted to flag in case you were inclined. If not, of course, your prerogative.
Normally we
Okay.
don't.
Well, no,
If you're requesting that, I'm happy to accommodate that request.
I simply didn't know if you saw the hand.
are you more comfortable if we hear from the attorney? Because I think that we've gotten a recommendation. I'll let the attorney, I don't normally do this, and I thought that I had stated that previously, but, you know, if the attorney would like to come up, 3 minutes.
Certainly, I'll be very brief.
Thank you.
Madam Chair and members of the board.
Thank you.
My name is Kevin McRoy. I am counsel for Jonathan Bernier, who is a shareholder in Ignited Culture. And he is acting in a way to try to protect the licensee and the corporation. There have been a number of documents which have been submitted to this board and to the Commonwealth of Massachusetts that are not correct. We believe they are knowingly false, not just with regard to shareholder interests, which we have looked at the documents that have been filed. Those are not correct. It is our position they are not correct at all. We don't believe Ms. Bernier should be, Ms. Ruse should be a shareholder at all. There are originally 4 shareholders, all of whom own more than 10%. That information was changed without authority, without ability, and documents submitted to this board claiming that it was properly done. It is not. There are also other documents that we have been found that have been submitted to this board that are fraudulent, including a lease, which we question why it was done to begin with. It was backdated to a time before the corporation even existed. So we have problems with that. We also have problems with reported investments into this company. As far as I'm aware from the filings that have been made that I've been able to access on the system, it only indicates that Mr. Ruse has invested $1 million into this company. I have not seen one piece of paper that shows that he invested $1 in here. However, there are in excess of $4.2 million invested from other investors in this company that are not disclosed. So that's just the tip of the iceberg with this. There is a case that is pending in Bristol County Superior Court. There will be a hearing next week. And so I certainly understand it. My client is very concerned because this is an important field for him, that he is not wrapped up into the fraudulent trend.
I've seen this before,
Sure.
not handled properly in another case.
Okay.
And so so my question to you is, if we don't renew this license today, what does that do to your client's interest?
Well, obviously, if the license is going to expire, we are trying to protect the company. We obviously do not want the license to expire. What we are requesting is that if it is allowed, to allow the extension to be further extended for renewal while an investigation takes place. I don't know if that's, but we do want to protect the company. I want that understood.
Is it possible, any sort of like when we have the host community agreements that are not legal, and we do have prorated, is it possible for us to, on month by month, could we temporarily extend this license with the, because I want to make sure we don't throw out the baby with the bathwater.
Right. I just want to make sure
Yeah,
that.
I've seen this before. Can I ask, when did you first raise this when was this first raised with the commission and the investigations team?
Mr. Bernier is here. Mr. Bernier, when was the first time you reached out to the CCC, sir?
We reached out to our lead investigator back in December. Once I started putting pieces of the puzzle together on what was going on.
Right. And so,
No, go ahead.
oh, okay.
It just finished.
So, the concern that we have is that this board does not stamp the approval that the owners are who they're purported to be in the filings. That is not true. And there are other issues that we have. For example, there was a build to suit lease that was done that's purportedly dated December 5. It's signed by both Gabriel and Sabrina Ruse, who we believe are the cause of all of this issue. And it's dated December 5, 2022. Ignited Culture didn't even exist then. The name hadn't even been thought up of. And so that's, for example, that's a concern. And why that was done, we don't know, but there's no logical, good faith reason that is done.
If documents have been submitted, that's problematic. If this is
Right.
January, February, March, April, that's 4 months. And we're, you know what I mean? If it was December.
We don't know when that lease was submitted to
What I'm
us.
saying is, when did you first notify the commission that this was a problem?
December, Mr. Bernier reached out to the investigator in December.
And what response did you get?
I didn't get no phone call back. And
Nothing.
I continued doing, that's, I had already obtained counsel at that point, and I started putting all my information together. And then when I submitted my complaint to the Rooses last week, they froze me out of the company, they kicked me out, no trust us.
So,
Okay.
So just so you-
Normally
just-
don't do something
right.
like this, but this is obviously.
so just so you know, a copy of the draft complaint and all of the exhibits. So we're probably talking 250 pages of documentary proof showing that what has gone down here is not correct. Mr. Bernier handed it to Mr. Ruse on April 6th, just before 7 p.m. at the business premises. It was a demand for suitable action by the company to say, hey, here is a draft complaint, a verified draft complaint, saying of all the things that we know, or at least believe are going on here that are wrong. Please take suitable action to protect the company. The next day, he was frozen out of the company. He had his CCC badge revoked. They are blocking all corporate records from him, and they served him with 2 no trespass orders. So who does that?
I've seen this before where I had someone in a similar situation who was filing requests for information and we were giving it to them, and I was concerned and confused about that because it seemed that that's public information,
Right.
that especially when someone has been on the license. So this is not the first time that I've seen this.
Okay.
Commissioner Roy.
Well, no.
Oh, Executive Director.
Thank you, Madam Chair. Just a question on the extension possibility. One, we don't have a formal extension request, but to the question of where that would come into play, I believe there's 30 days of extensions within the general allowance of extensions that have been voted in the past that would be available. Obviously, the recommendation is to let the process play out on the ownership. And if it is found to be that things have been presented fraudulently, obviously that will follow an investigative path. And that, but to the answer to the question of the waiver, the extension process, there are 30 days left on this licensee, but we do not have an extension request from the license holder.
So what do we do apparently this was first raised in December. So could I ask the general counsel to come back up? Because if this was raised in December, then we've had notice and we've been completing this paperwork. And we've had notice that this might be fraudulent. So if the general counsel, again, and I don't know if this is appropriate to the general counsel or enforcement counsel. So what do we do if we have had notice, prior to our staff completing this paperwork for the renewal today?
Good morning again, Madam Chair and Commissioners. I have no prior knowledge of this information. I would have to defer to licensing. I will say that the previous recommendation that I had outlined still stands. I see this as being 2 separate processes. We have our own internal process, which has been gone through. I can let licensing speak to that process. The separate civil process that my brother has initiated in this superior court will play out, and obviously the commission would abide by any rulings that come out of that.
As an agency, if we have notice that there may be fraud involved in the paperwork, what duty do we have under the law to ensure that the paperwork's not fraudulent? That's not, I don't need licensing. I'm trying to figure out what the law is.
Well, I mean, that would defer to our process. And so licensing and the enforcement council have a process that they follow in these sorts of situations, and they would follow that process.
I'm just going to repeat the question. If we have notice, I understand there's a process, but in the course of completing that process and review, we now have notice that there may be fraud. Does the commission, having notice of fraud, place any responsibility on us to do additional due diligence, or do we just ignore that?
Well, I guess I have some issues with the phrasing of the question. These are allegations of fraud, so we must take them as such. So no determination has been made either way on this. So I'm trying to answer the question, but the question's a little bit difficult to answer the way it's been phrased.
I don't know if you understand what I'm trying to get at. We have a process. We go through due diligence. I have observed this in another case, actually a couple of cases. And so what is the duty of the commission when they have been notified by someone who previously has been on the license and has been an agent, and there is notice of potential fraud? What is our duty as a commission to determine that what is being provided as evidence to allow this renewal? What's our duty as a commission? What do we have to do?
Well, I mean, our duty would be to go through, whatever documentation we have and to complete the review on that in the normal course of affairs. I'm not sure I
Do
understand the question further than that.
The question is, if we have notice that what has been submitted is potentially fraudulent, including lease information, it's all of the information that gets submitted is supposed to be submitted truthfully, right? So what is our duty to ensure that it's truthful?
Again, I'll defer to our duty would be to look into whatever is submitted, to follow the process. Again, these are allegations of fraud. The licensing team would look at this initially, go through their normal process, and they would forward this to enforcement counsel to follow up and do their due diligence. Well, there's a separation of powers here, so and I can't speak to the licensing, what licensing is done.
Madam Chair,
Yeah.
if I may, I'd just like to clarify, the communications that came across in November and December were not in regards to this topic. What was received was on 4/6. We need the time to look at the issue.
Okay.
If you'd like to discuss the extension possibility, it would be outside of our normal process. But we can have that conversation certainly. Otherwise, again, if there is something in what's in the packet in front of you and the staff that is inaccurate, that will be discovered through the process. And we'll also have the benefit of the outcome of what is apparently ongoing litigation.
I put the motion language from 2022 in the chat, which was for compliance issues. So it's broad, it was worded broadly, and it was not germane to HCA's at that time. So also want to read the language when a renewal is brought to the board by the staff. Is there any language that asserts, in other words, by us ratify or us voting on this, are we saying everything is in compliance? And that's usually what we're saying when we vote in the affirmative. We're saying, to the best of our knowledge, everything is in compliance based on the executive summaries we get. And so we don't know if everything is in compliance right now. And so that motion language is broad enough, perhaps, so the license doesn't expire, perhaps could get an extension, would allow our team to do its necessary due diligence into these allegations. Perhaps is an option, because I don't know if I'm personally comfortable saying this license is in compliance based on the testimony we just heard and the documents. Although these are assertions and allegations, they're still highly concerning.
So, but what I'm seeing here from our executive director, it says, for the record, the letter was received on 4/6/26. But what I'm hearing is that the gentleman alerted the investigations team. So are you saying that the investigations team did not receive that?
The prior communications from November and December did not relate to what was received in the letter.
Can you clarify what was received?
Received in the letter are the allegations that you brought the attorney up to
But
enumerate.
what was received?
It was related to, I'm not sure I understand the acronym.
And maybe attorney, yes.
Thank you. Who was it received from? because Mr. Bernier made a telephone call to the investigator and left a voicemail, but never heard back. I will say that there was also an email sent from Mr. Bernier to pretty much everybody in this commission, first addressing his concerns probably a couple of weeks ago. And I, it was acknowledged it was received, but nothing ever happened from it, which, then brought on my letter. So,
Madam Chair. So just, I'm looking, I'm in the board book. I'm looking at the executive summary recommendation on a final license, and the language, the licensee has demonstrated compliance with the laws and regulations of the Commonwealth and suitability for licensure. Therefore, the license is recommended. Happens to be final one. As part of the approval of a final license, the commission authorizes staff to take all necessary actions to review compliance with the above referenced conditions and to approve the commencement of operation. Now that have that language for a renewal, but one could surmise that the same threshold applies to renewals. The licensee has demonstrated compliance with the laws and regulations of the Commonwealth and suitability for licensure. Now, sounds like there perhaps is a question mark here. And we are saying, yes, they have by voting in the affirmative, we're saying they have demonstrated compliance with the laws and regulations of the Commonwealth. Now,
I want to just ask, do you confirm what Commissioner Roy's interpretation of what we're doing by approving them? The General Counsel Chudapade?
Thank you, Madam Chair. What I can say is that the review of the materials would be an acknowledgement or a statement by the board that the conditions for renewal have been satisfied.
I don't think that's the question. I think the question is, are we confirming that they're in compliance with all applicable laws? That's what we're saying.
Well, you're complying that the licensee has satisfied the requirements for renewal. That is the nature of the review process and the renewal process, is that you are reviewing those documents to ensure compliance with the requirements for renewal.
Does compliance assume that all applicable laws and regulations are being appropriately followed?
Well, I mean, I think that's a little bit beyond the scope. I mean, when you say all laws and regulations, again, there are allegations here that my brother has raised relating to the licensee. The licensee is not here in this room to present their side of the story. So, we're hearing one side of the story here, which is a separate matter entirely from the renewal license issue that is before the board today.
Madam Chair, the Director of Investigations
Yeah,
wanted to
please.
address some of what was stated previously.
Thank you.
I'm not sure, we might be running out of room.
Thank you, Madam Chair.
Again, sorry, this is,
Thank you, Madam Chair. Yes, so from written records that we have, the lead investigator did not receive this complaint until April 6th. In terms of process, when we've received complaints, they are looked into. So we can't really speak about specific allegations or what was alleged. It's been summarized to an extent. In terms of whether a phone call was received, the lead confirmed that he was made aware of this complaint on April 6th. So if there were voicemails sent, I'll have to check back in with the lead. The communications that were sent in November and December, by the way, I know that was asked, those are compliance matters. There were some alternative security provisions, other alternative security provisions were submitted to the commission. So that was being reviewed by the lead. And we were in communication with the chief law enforcement officer regarding that request as per process. So that was just a routine compliance matter that they requested.
Commissioner Roy?
so it sounds like we have some internal questions we need to suss out. And I don't have enough information to
No,
vote
I
and
mean,
determine.
I think that the issue that we're raising is that, and I'm not sure I'm not sure, I'm hearing compliance, but I'm not confident in what I'm hearing about. Again, we have sort of conflicting evidence here. And again, I'm not questioning anything, but I've seen this before. So I just want to make sure that we're not voting on something that assumes that everything is compliant. If we did have some information
Okay.
that there might have been some violations of law. Commissioner Bennett on.
I want to state that I agree with Commissioner Roy. I too am uncomfortable, given that these fairly serious allegations have been brought to light. The way that I see it is when we are considering a renewal, we look at the paperwork. The licensee who's applying for renewal signs that the information submitted is accurate. And so generally it is reasonable, in my opinion, for our team to accept that as at face value. So we are not independently determining that everything they say is true. We are taking what they submit to be true and then determining whether the conditions for renewal are met. In this case, though, we have received contrary information that calls into question. And so I do feel like in this case, some additional review is warranted. If nothing had been called into question, I would say our team can just accept at face value everything on the paperwork. I'm not comfortable doing that in this case and would rather go with some kind of administrative extension or whatever tool we have available to allow our team to look into this, given that they have only recently received the concerns.
So I'm just trying to figure out, because again, we've done this with host community agreements, when people weren't in compliance. Commissioner Roy?
I think Director Colville said this will expire in May, right? Director Binkowski. Okay,
So
May
it's like-
what?
May 13th.
Okay,
Oh, so that's-
okay, and today's the 16th. So we cannot just grant that. You have to apply for the extension, correct? The licensee would apply for the extension.
Okay, so if I might, that brings up a concern that I have, because the people who are purportedly speaking for the licensees are the peoples that we have alleged are committing.
I see.
So, or these activities and making statements that are not accurate, at least to the best of our knowledge and belief. So, best of my client's knowledge and belief. So the concern here is he doesn't, being involved with this commission is very important to my client, to Mr. Bernier, and he does not want to be grouped in with these other activities because he intends to continue to be involved in this industry.
Can we extend this license pending a more fulsome investigation into I understand there's a lawsuit, but I also understand that compliance aside, I understand that we as commissioners have an obligation to ensure that the facts that are submitted to us are accurate. And if we have some reason to believe that we've taken at face value something that may be fairly easy to figure out, right? Do we have the ability, I'll ask our general counsel, do we have the ability to approve the renewal of this license pending a further investigation? Again, we're sort of handicapped here because we don't know what's going to happen with the new bill, the new law. So we want to make sure that we're not, doing anything that, it confuses things more than they're already. Commissioner Roy?
Can we remand it with an extension pending an investigation? As opposed to approving and saying we're some way approving that it's compliant, if we remanded it with an extension pending an investigation. That means we're not approving because we don't know if it's compliant and we don't know if they're following the laws and the statutes. But
That's what I'm saying.
this board has remanded licenses and we have remanded in the past. So it's been done, but the thing that hasn't been done along with it is granting an administrative extension pending the investigation.
Yeah, or could we? I'm just trying to, I'm trying to figure out how we get both things done.
Well, motion, I'm sure we could,
Yeah.
we've granted authority. It would be through motion language.
Again, if we retain the judgment and we direct the executive director to the license, I'm just trying to figure out how we can not put this license in jeopardy, which is going to be expiring in a couple of weeks or 3 weeks.
Yeah.
But allow us to be confident that we're not approving something that may be factually inaccurate. So.
Yes, thank you, Madam Chair. And again, I just want to note it that we're trying to look out for the licensee and the corporation. We do not want the corporation to cease doing business.
Right.
We just don't want to be grouped in with the statements that have been made to this board, which we feel are knowingly incorrect. And documents which we we didn't know, my clients didn't know anything about any of this when it was being done. Everything was done by one or two individuals only. So he was not made aware of all of this before. If he was, we would have been here sooner.
Okay, all right, so do we remand it? I mean, you say.
Maybe we need a 5-minute legal break to huddle with legal because this is we have precedent for half of the equation. We don't have precedent for the other half.
And I'm not comfortable with the opinion that I've heard that the paperwork's the paperwork.
Yeah, no, and I'm not comfortable. I'd have to vote present because I'm not comfortable voting in the affirmative based on what I heard today. So I don't know, and I think Commissioner Bennett shares my
I
sentiment.
appreciate your prodding me to hear from the attorney because I
So I'm just wondering if there's motion language that can be constructed that would remand the license back pending an investigation, but put it on an administrative extension. I think it could be done. I think it can be done, but
So why don't we ask our general counsel to huddle with his team and maybe draft a motion and we can we can vote on the renewal licenses, not table, but we will not include Ignited Culture and we'll try to figure out how we can do this in a way that ensures that all laws are being complied with and that we're not voting on something that that we may have reason to believe might not be.
Director of Housekeeping issue. Did we vote on Phytopia?
I believe we did. Yeah, because I remember
I
saying,
always cross it out.
yeah, no.
Why did I cross it out?
I did. I crossed it out. So yeah.
Perfect.
Usually
One
I'm
of us
the one
crossed
that
it out.
forgets it.
Thank you, just housekeeping.
All right. So why don't we?
Thank you, Madam Chair and members of the board for your
Why
time.
don't we figure that out and Attorney Gooden and thank you. If you could just maybe help us. Thank you, Catherine. If you could just help us figure that out, I'd appreciate that.
Thank you.
I appreciate it. And again, I thank Commissioner Benedon for, well, I'm pleased that we did this, because again, this is not the first time that I've seen this. And, so, all right. So, I will entertain a motion to renew the licenses recommended by the staff, 1 through 5, 7 through 17. Do I hear a motion to approve, Commissioner Roy? Do I hear a second, Commissioner Stebbins?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon?
Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Chair O'Brien votes aye. It passes unanimously, and we will address Ignited Culture once we have additional motion language from our team. Right. So, sure. Okay. Recommendations on final licenses. Okay. Yes. Staff recommendations on final licenses. Sorry, I'm going back and forth, and I'm getting confused. Thank you. Sorry about that.
There are 3 adult use and 1 medical marijuana treatment center licenses for consideration today. Commission staff have reviewed the applications for compliance with applicable laws and regulations and are presenting them for the commission's review and vote.
Thank you. Are there any comments or questions from my fellow commissioners? I hearing none, I will entertain a motion to approve these 4 final licenses. Commissioner Roy, do I hear that motion? Do I hear a second? Commissioner Stebbins?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon?
Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
They are passed unanimously. Okay. Check. Okay. We have some provisional licenses here. But why don't we go first to sanctuary medicinals that I believe Commissioner Stebbins has a condition?
I do. Thank you, Chair. My proposed condition for sanctuary medicinals, MRN 285402, is prior to final application for licensure, consider revision to your positive impact plan goal number 2 and considering hiring or other strategies to impact disproportionately impacted area designated communities in closer proximity to the town of Saugus in accordance with 935 CMR 500-101-1A11, 935 CMR 500-103-4B, and provide an update to the CCC licensing division. Again, just for consideration, this licensee would be opening up in Saugus. They've identified their interest in supporting DIAs of Lowell and Fitchburg, and just want them to have some consideration of perhaps supporting Lynn and Chelsea, which are in a little bit closer proximity.
And does anyone have any questions or comments about the condition, or Mr. Roy?
I just want to segue into red tape a little. We heard back that conditions are considered like red tape, adding red tape to licensees who are already overly burdened. There's talk about, although well-intended, they haven't had the full effect. Positive impact plans have not had the full effect that they were intended to have. And it literally have just become red tape for many folks. You know, and obviously with the new law, the intent was Commissioner Benedon and myself to work together to strategize on ways they would be more impactful.
I'll just say, I don't support the condition, so I'll take a call of the roll. If
I just feel it's red tape at this point, and they're overly burdened already.
people would like to, I'm opposed to the condition. I'll call the roll. Commissioner Roy,
No.
Commissioner Stebbins,
Yes.
Commissioner Benedon.
Yes.
Okay, it does not pass. Okay, so we will now go directly to,
We have to pass the license.
yes, no, we're going directly to the licensee. Yes. Okay, so going directly to the provisional license of Sanctuary Medicinals. Sorry, I'm screwing.
The last applicant, this is
Yes,
the
I
Sanctuary
apologize,
Medicinals, that's okay. The proposed location is 181 Broadway in Saugus. They are seeking a marijuana retailer license, and the applicant received general review. Additional information is contained within the executive summary for the commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Are there any further questions or comments regarding Sanctuary Medicinals provisional license? Hearing none, I will ask Commissioner Benedon, will you move to approve the provisional license of Sanctuary Medicinals?
So moved.
Do I hear a second? Commissioner Stebbins.
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. It passes unanimously. Now I'll get you back in order. Apotho Therapeutics, Dartmouth Manufacturing.
Apotho Therapeutics, Dartmouth Manufacturing, Inc. Has a proposed location of 757 State Road in Dartmouth. They are seeking a marijuana product manufacturer license, and the applicant received general review. Additional information is contained within the executive summary for the commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Are there any questions or comments regarding this provisional license? Hearing and seeing none, Commissioner Roy, I'll entertain a motion to approve the provisional license of Apotho Therapeutics, Dartmouth Manufacturing.
So moved.
Do I hear a second, Commissioner Stebbins?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon.
Aye.
Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. Passes unanimously. Moving on to Bullrush LLC.
Bullrush LLC has a proposed location of 1 Cabot Street in Holyoke. They are seeking a marijuana microbusiness license, and the applicant received expedited review. Additional information is contained within the executive summary for the commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Are there any questions or comments on this recommended provisional license? Hearing and seeing none, Commissioner Roy, will you move to approve the provisional license of Bullrush LLC?
So moved.
Do I hear a second, Commissioner Stebbins?
Second.
Having been moved and seconded, I will call the roll. Commissioner Benedon.
Aye.
Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye, passes unanimously, and I will note that there's a typo, LLC. Is that a, it's just an extra L. Okay. Passes unanimously. Moving on to Depkin Corp.
The applicant here is Depkin Corp. The proposed location is 204 North Beacon Street in Boston. They're seeking a marijuana retailer license, and the applicant received general review. Additional information is contained within the executive summary for the commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you very much. Are there any questions or comments from my fellow commissioners regarding Debkin Corp? Hearing and seeing none. Commissioner Benedon, will you move to approve this provisional license?
So moved.
Commissioner Stebbins, will you second that?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. It passes unanimously. Hudson Botanicals Processing.
Hudson Botanical Processing LLC has a proposed location of 14 Kane Industrial Drive in Hudson. They're seeking a marijuana existing licensee transporter license, and the applicant received general review. Additional information is contained within the executive summary for the commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Are there any questions or comments regarding Hudson Botanicals Processing? Hearing none. Commissioner Roy, will you move to approve this provisional license?
So moved.
Commissioner Stebbins, will you second that?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon.
Aye.
Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. It passes unanimously. Move on to J-BAM.
The applicant here is J-BAM Incorporated, doing business as Firehouse. The proposed location is 71 Downing Industrial Parkway in Pittsfield. They're seeking a marijuana retailer license, and the applicant received general review. Additional information is contained within the executive summary for the commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Are there any questions or comments from my fellow commissioners? Having been none, I will entertain a motion to approve the provisional license of J-BAM. Commissioner Benedon, will you make that motion?
So moved.
Commissioner Roy, will you second that?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. It passes unanimously.
Chair,
Yes.
I still don't believe we voted on Vitopia.
Okay, I will entertain a,
I mean, unless the staff wants to go back and watch the,
we'll take a, I will entertain.
in my mind, we have not voted on
I
Vitopia.
apologize. I crossed it off in, I will entertain a motion to.
Well, should we go through,
She already presented it.
well, maybe,
Sorry,
I
my.
can present it.
yeah, let's just dot our i's and cross our t's. Let's present it again. Thank you.
The licensee here is Vitopia Incorporated. They're seeking a change of ownership and control over one medical marijuana treatment center license and are requesting to add 2 individuals in 1 entity. Additional information is contained within the executive summary for the commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. I will entertain a motion to approve the license for Vitopia. Commissioner Roy,
So moved.
Commissioner Stebbins, will you second that?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon.
Aye.
Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. It passes unanimously. And again, my apologies. Thank you. Thank you for raising that.
Of course.
Madam Chair, would you like to take a break and we'll bring back the other licensing item, or do you
Yes.
want that later in the day?
I could use a break.
Oh, please. Okay, very good. I will entertain a motion for a brief recess until 11:15. Commissioner Roy, having been moved, Stebbins having seconded, all those in favor?
Aye.
We'll be back at 11:15.
Thank you.
That's just Is he? Yeah. Here. You know where our general counsel is? Okay, so do we want to get an update on the deadline while we're waiting for that? We want to move forward on that? Yeah, why don't we do that? Okay, I'll ask CFAO Lisa Schlegel and the executive director to talk about an update on the tip line. And I did want to note that worker activist Danny Carson had been here earlier, and appreciate all of his work to bring this issue to the forefront over many years. So anyway, thank you. I don't know if the executive director or the CFAO, who's going to start here.
Thank you, Madam Chair. I will just kick it off, but obviously the CFAO as well will go through some particulars in regards to this. I don't know, to be honest, if our slides are going to work for the audience. So I know that you have access to them. They should be in the packet, so I apologize.
Logged online since we need to be in.
No, I'm doing that right now.
Oh,
I just had a difficulty. Thank you, Bill.
thanks for noticing.
Thank you. And actually, let me just, as we come back to break too, we have the slide up as far as I can tell. So we are, if you're off camera, if you could just identify the speaker for the future of the minutes and for the public's interest. Obviously, we're having some technical issues with how we normally broadcast.
When people speak, we want them to identify themselves.
If your camera's not on, if you could just identify.
We're having a little
Okay.
technical issue trying to get Commissioner
Yeah, I
Roy.
was buffering.
I think we're on now. All right. And right. So if you don't have a camera, I'll just obviously identify the speaker as best we can. Okay. So related to the tip line, I wanted to just give a brief update. We do have some slides the CFAO will go through in terms of upcoming procurement. I just want to highlight as well, obviously, we've been discussing this back to March at this point when the board authorized the creation of a position, which was eventually titled the Complaint Resolution Administrator position. That job description has been created, has not yet been posted, given the hiring freeze and a few other financial items that we'll talk about in the future here, but also will coincide with what we're talking about in terms of an upcoming procurement. Additionally, a workflow of how that position would work between a variety of different departments and potential tips that may come in through that line, and then generally re-coordinating all of the external lines that come into the commission is part of that workflow. So that has been developed and ready to go, which will be part of a procurement looking at software solutions and other options that would go through this process. So a project management team, PMT, was created. And it has changed slightly given language in the bill, which the CFAO, Lisa Schlegel, will give a quick summary on and then answer any questions.
Thank you. CFAO Schlegel?
Yes, so as ED stated, we did start, the first kickoff was March 31st. There was a discussion on whether to go with an RFI or go directly to RFR. After further information and seeing what's in the bill, it's decided to go to an RFR. We think we can get this processed and done. The goal is to have it done before June 30th of this year. The bill does, if it is signed, does allow for an anonymous complaint portal, which is exempt from public records disclosures. So that will all be built into this. And as I said, the team has already started to meet and is moving forward with that with like I said, hopefully by June 30th.
So this is an RFR, and this is one of the things I'd raised some time ago because I'd been on the board of a bank, and we actually, I remember 4 years ago calling, one of these. So again, just for the public that's watching, I know they do this for banks, and then they divert the calls to the appropriate, if the executive director is committing fraud, they do the chair. If the chair is committing fraud, if a teller is doing something, it goes to different people. But could you just kind of explain, what that is, and just exactly what we're putting out a potential RFR for?
Absolutely. There's a number of ways of intake on this, whether it's through a portal or through a hotline. Most likely there'll be both options. Again, we'll look what the RFR is and it will come through. We do have a flow chart of the type of complaint and where it would go, where it's directed. There'll be multiple avenues for that, and it'll come through based on a flow chart that's already been prepared by our CTIO. And again, if the RFQ, we can go directly off a state contract, but we wanted to cast a wider net and do the RFR to see what's available out there for vendors. Again, it's dependent on funding.
Again, can you just, an RFQ means that we have the predetermined list of vendors that are already. An RFR would say the whole world can come, even if you're not on that pre-approved list, which lowers the barriers to be able to do business with them. Am I restating that
Exactly. The
correct?
state has existing contracts on combis. You know, we can go RFQ and get quotes from anyone who's already contracted with the state under these contracts, or we can cast a wider net and do the RFR, which allows vendors who are not on state contract to submit a proposal.
Thank you.
Again, we look at cost and comparisons before.
And what, have you seen them? And again, you obviously haven't sent anything out, but, you know, I remember, you know, when I initially was doing some homework on this, I remembered being surprised. It was only about 20 grand a year. And it didn't seem to be very expensive. And it's you know, it automates a process again that was still, and I applaud the legislature for having allowed this not to be subject to public records request, because I've already had a number of people saying I'm waiting for that to be up, because I want to make sure that I can make some of these anonymous reports. So I know that there are a lot of people out there that are looking forward to this. So, but do you know ballpark? Have you seen like ballpark what the numbers might be?
We really don't. What we'll do is when we issue the RFR, we're going to include some numbers of estimates on, and I think it would go to the number of complaints estimated, and it would probably be based on that, on the number of staff they require. And that could change, you know, there'll probably be different tiers based on the number of complaints and the cost. So I think the 20,000 is probably a low estimate, a minimum, right? And that would be a minimum, and we would see what the RFRs come back with. But I do believe there would be different thresholds based on the number of calls that came through or complaints that came through.
Thank you. Commissioner Roy?
Oh, it's,
Oh, sorry, Executive Director?
Thank you, Madam Chair. Just going to add one note here on the anonymous nature. If we could just go to the next slide, just so people have as well the kind of timeline that we have here. Obviously, we are hoping that the cost will not be significant or a barrier, but this generally will align with the FY27 budget cycle. And then just on the note for the anonymous nature of what we will now be allowed under the proposed bill, which has not yet been signed, if it were to be, then that will now go into the the RFR as well. And then in that element, we've looked at a few other jurisdictions. Colorado, I know, is one, but there are some others as well that have existing processes in which they are allowed to have the anonymous tips in terms of the PRR process and those types of things to protect. So we will have those processes also aligned. And so all of this should be heading towards FY27. And so we will, as the board has done, continue to promote the need to fund these initiatives to make sure that they get to the finish line. Thank you.
Thank you. Commissioner Roy, you had a question?
yes, I do. Reading the language from the legislature, it's more than just a tip line. The commission shall establish and maintain an online portal. So to the CFAO, to the chair, we probably need to do the same or work with Paul, our CTIO, because that's shall, the portal is shall in the statute, which is not synonymous with a tip line. They're different things. So it also says on line 272, the commission may, in addition, maintain a phone line or any other line of communication that it considers appropriate for the anonymous submission of complaints information. So we need to cast a net that includes how we're going to set up a portal in addition to the tip line.
Right, and part of this is whether it's an in-house portal or something that's managed. Again, the portal will be there. We get the tracking information from that if it were to be outsourced.
And we say portal, one tends to think digital on a computer, right?
That's the intent, yes.
Mhm.
But it would also have, in many cases, a hotline that goes with it as well. And if it was outsourced, that data would be input from the hotline into the portal.
So is that baked into the current RFR?
It will be.
It will be baked in.
Yes.
Okay.
Commissioner Benedott?
So is the expectation at this stage that the online portal would be done internally and would be cost neutral? And that's why we're not rolling that into this, or are we not considering that yet?
Where? CFAO?
We are looking at both options. Again, because there is some safeguards in doing this completely outsourced and the anonymity and getting the data tracking from that portal, we're looking at both options to see what the cost benefit is for each and what we get for any additional funding to be able to implement with an outsourced.
And I think that it's also notable, and this is also, you know, one of the things that I referenced, you know, from my experience being on the board, you know, sometimes you don't want anybody who's affiliated, connected, maybe has lunch with, you know, doing that internally, and that's why the external process, you know, helps to make it as independent as possible. Any, Commissioner Roy?
I know you said fiscal year 27. How granular can you go? Like,
The current process for the PMT team is to get vendor quotes in by June. So that's our timeline now. When you say granular, so most likely it would depend on.
like we approved this probably a year and a half ago in the tip line and the complaint resolution administrator. And, you know, much to my frustration, which I repeated ad nauseum, that why isn't it up? And I understand there were factors like a hiring freeze and budget constraints. And that was in regulation. Now this sits in a higher perch. It's in statute. And so you know, there is a sense of urgency. You know, people want to see things happen immediately. And today we're going to talk about how we execute on the purchase limits and the advertising effective immediately. And so there are a lot of workers, you know, spoken to workers anecdotally. Danny Carson was here, and people want the protections of anonymity. So all I can say is there is a sense of urgency with this one too.
I think that this sort of takes it out of our discretion. And this is, you know, one of the things that's going to be on the executive director to find. We just saw the House budget, I believe, came out with, in essence, $300,000 less than our current year appropriation. So this is going to put greater pressure again to do that management audit that I think is really, I mean, we don't need to hire anybody to do a management audit, but that probably is something that needs to be in process right now, because that's not going to be something that's discretionary.
Yeah.
So any other questions?
And thank you. And again, you know, on behalf of every worker out there, I am, you know, imploring you to have a sense of urgency around this anonymous portal and tip line. And I know there are budget constraints, but it's in statute. And I know we have a year. My fear is it would go to a year when I think there's an urgency to get it done sooner rather than later. So
Exactly.
just wanted to share that. Thank you.
Okay, I don't think there's any questions. And again, just acknowledging that Danny Carson was here, who worked with Lorna McMurray, and has been really pushing hard to make sure this has happened for almost 4 years. So I applaud his work. Thank you. And next, we're going to the discussion on progress on change of ownership process motion from our March 4th, 2026 meeting.
Madam Chair, should we just do ignited and then the way?
Oh, yes. Oh, is our general counsel?
I know you
ready to go?
people here in the
Ready to go?
audience.
Let's get it and then. Yes, thank you. Thank you for that. Please,
Thank you, Madam Chair. Thank you. And thank you for the time to discuss this with the team. As you know, we have had 2x2s with all the commissioners now, and I think we have a proposal here for your consideration. There is motion language in the group chat for you to consider, which I think we've already discussed, but the motion language references the statute, chapter 94G, section 4.
Could you read the motion just for the benefit of the public? Because they have to do a PRR and that will take a long time.
Yes.
I can read it.
So-
Commissioner Roy, go
Yeah.
ahead.
Subject to Massachusetts General Law 94G, Section 4A6, move to renew the license subject to the outcome of the commission's investigation into the allegations received on April 6, 2026.
Just if I may,
Please.
just to correct Commissioner Roy, minor, it's section 4A sub 11, not 6.
Oh, I'm sorry.
Sorry.
I had my Roman numerals mixed up. Thank you.
Thank you, Chair. Appreciate the suggestion here from the staff. Obviously, all due respect to the folks in the room, we're mindful that these are allegations, hopefully to be proven out one way or the other. Obviously, if it is deemed to be their allegations are found to be truthful, obviously that brings this matter probably back for potential enforcement issues if they're found to have been fabricating information that was included in their renewal package. But I'm comfortable with the motion as it's written.
Any further questions or comments? Commissioner Wright?
If the general counsel could read from the statute, I think that would be helpful.
Sure.
Thank you.
Read that. So section 4A reads, the commission shall have all the powers necessary or convenient to carry out and effectuate its purposes, including but not limited to the power to, sub 11 is deny an application or limit, condition, restrict, revoke, or suspend a license. And what the word condition is explicitly in that language.
Are you satisfied?
Everybody comfortable?
Thank you. Okay, so we have the motion. It's been read by Commissioner Roy. Commissioner Roy, I will entertain a motion to adopt that language. Are you comfortable with that?
Yeah, as applicable
To,
to
yes.
MRR 207421, Ignited Culture Inc.
Yes, the motion to approve Ignited Culture, subject to the language read by Commissioner Roy.
So moved.
Okay, Commissioner Stebbins, do you second that?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. It passes unanimously. Thank you. And again, I thank you, Commissioner Benedon, because I do think that a greater obligation, and I appreciate you raising that. Thank you. All right, so we've got.
Thank you, Jamie.
Tip line. All right, so we will go through a discussion, and I'm going to take some things that we'll go next to discussions of project on a progress on change of ownership process motion for March 4th, 2026, and that is Executive Director Ahern and myself. This had been raised to me regarding a licensee, well-established, vetted for many, many years, and given the article that was in the paper yesterday about Pure Oasis just suddenly going out of business. We had a business in Grafton just abandoned. We had Rasta Roots in December close. And we know that we are looking at the issue of receivership. Pure Oasis, apparently there are 60 jobs that are involved in that. So one of the things that we're trying to do, in addition to making the receivership process as seamless as possible so that we can save jobs, we're also looking to, again, reduce red tape when it comes to change of ownership. So Executive Director and I were talking about ways that we could, it's not a suitable licensee, but we were talking about language that we could put in place that if someone had previously been vetted, they're currently a licensee, we don't need to go through the same process. And so, maybe we can, just discuss if there's been any research done on that and what we can do within our current authority to make sure that these processes happen as quickly as possible, because that one licensee called me and said it was taking months. That person had been in business for some time, had no problems, and was trying to make sure that they saved jobs. So maybe you can comment on any, information that you found, Executive Director.
Thank you, Madam Chair. So if we could go to the next slide, just want to reference, we're on agenda item number 2, which is the discussion of progress. This is the motion. And so we did have this obviously lined up for May based on the bringing it back within 60 days. But as you just noted, item number 4 on the agenda is a little bit more nuanced within, I think, the discussion the chair and the staff would be looking to kind of get some direction from the board on, which is one of the requests that I think, it could certainly fall within red tape. It could certainly fall just within kind of direction from the board here is the point that was made from one of these licensees saying it's taking too long from their perspective on a change of ownership or a transfer of ownership is that we're in good standing. And so the point back on that is, I think that is a term that is certainly used in a variety of different ways. We may want to consider a different term. Obviously, we have certificates of good standing that come from DOR. We have a variety of other items, but the intent, I think, is the discussion that the chair is looking to have with the board is if there is a desired process to say for somebody going through these types of processes, administrative processes that does not have any requirement or should potentially go through a different process, a less arduous process from our financial reviews, from our just background reviewing in general, that we would need direction from the board specifically to say, what are the categories of yes or no that would allow us to say somebody is in good standing or an equivalent term that would allow us to go through a less complicated process. Obviously, there are some of these change of ownerships that are incredibly complicated, and some of them will always take time.
Yeah.
Right. So I think that is the intent of the conversation, and staff certainly would look for any direction that the board may have on what you would consider to be a licensee in good standing that we could then put into a definition and add to our processes.
James Stebbins?
Just a quick question.
And I'm probably
Thank you, Chair.
conflating the two, but they're related, so.
No, I appreciate that. And this topic is come up, reading through the motion from back on March 4th. I'm wondering if we can't also include consideration of a process when somebody is trying to make a change of ownership to an employee. Not sure what that does to a change of ownership process, but if you're adding employees, chances are most of them are not going to be reaching that current target of 10% ownership, whether we might consider possibly even fold back into this motion to say, what can we do to streamline employee-owned
But if they're not,
moving to an
they're
employee
under
ownership?
10% threshold, does that even apply?
That's a good question.
Well,
That's a good question.
I'm not,
Yeah.
The
Director?
If they have control, then
Oh,
no, like, so they have
control.
0% ownership, but if they're presenting that they have control over their license, they.
So like a CEO that doesn't have equity,
Correct,
which doesn't
correct.
generally happen. So, okay, so it's ownership or control.
Yes.
Okay, thank you. So that's someone who is responsible for the day-to-day operations of the licensee. So what would you like to accomplish with that? I mean, again, I'm just concerned. So we have two different things going on here. Is we have the whole process and how do we, execute it?
Excuse me,
But
sorry.
putting this on here, how do we, and maybe we can't do this on the fly today, but looking at the news articles, I am concerned about how we shorten that time. And I don't know whether we can provide direction to the staff. I mean, I don't know if it's non-enforcement, but it just feels like there are things that we could be doing to, in addition to evaluate the process. And this is a very long, Commissioner,
I've given it some thought. I have possible are you looking for a definition to help guide
yes,
staff?
yes.
We're looking for direction,
Yes.
I have given it some thought.
Thank you.
Okay. I put it in the chat.
Okay. So can I read this out loud?
Yep.
Existing licensee in good standing means a marijuana establishment, medical marijuana treatment center, or other commission licensed entity that, as of the date of submission of a change of ownership or change of control application, A, holds a current and active license issued by the Cannabis Control Commission, B, has no unresolved notices of deficiency, orders to show cause, or pending enforcement actions that could materially affect its license status, C, is in compliance with all commission reporting, fee payment, and renewal obligations. D, has substantially satisfied all previously imposed conditions of licensure, including operational ownership or corrective action requirements. And E, has not been the subject of a final commission imposed disciplinary sanctions such as suspension, revocation, or monetary penalty within the preceding 12 months unless specifically waived by the commission for good cause. Executive Director.
Thank you, Madam Chair. And I think to Commissioner Roy's point here, so I mean, I think one of the things we would want to be really clear on is the intent of the board here. So unresolved notice of deficiency, obviously you're aware of the process, right? They're giving us, how they're going to address that NOD. It may take time. They may be granted time. So, I mean, those types of timelines we would just want to be really clear on so that, somebody who may have a very simple, notice of deficiency to fix or something within their notice of deficiency to fix isn't negatively impacted. So those types of things, again, I mean, intent is helpful. Obviously, language is helpful. So just wanted to flag that because I know we've discussed in the past, not everything, not all items within a notice of deficiency are equal, for example.
So how do you suggest? Oh, go
If I may,
ahead.
are you suggesting strike NOD and just leave orders to show cause? Are you saying that an NOD shouldn't be a death penalty on this definition? And so therefore strike the NOD completely?
Executive.
Thank you, Madam Chair. I think I'm just trying to go off of the intent of the board here and in the past and say that I don't know that you want it to be that restrictive. If because there's a lot of reasons and there's timelines in which those.
You're comfortable with that? I mean,
Commissioner Benedict?
2 points. So I'm going to actually start with the second one, which is that if somebody does not meet the definition, perhaps because we have a very stringent definition of existing licensee in good standing for purposes of this more expedited, streamlined process that we're contemplating, nothing would prevent that person from still moving forward with a change of ownership. It just wouldn't be subject to the expedited review. And so assuming that that is the intent, and I think it is, that makes me less uncomfortable with having a more stringent definition. The whole idea is that we can kind of cut out steps that we in the past have found necessary. If somebody really meets this high standard, it doesn't mean that they can't proceed under the normal course. And so I actually would tend to be a little bit more stringent and say, we will have this expedited option and we encourage as many people as possible to use it, but it is there is a threshold there. And in particular, looking at the proposed definition, which has that materially language in unresolved NOD, which may materially impact,
you think that
that to me sets an appropriate line.
So you're saying using the language materially negates the potential
No,
that an NOD.
No.
Well, any open NOD could affect somebody's license, right? Because if they don't resolve it after some period of time, then it becomes an issue.
Yeah, and to the executive director's point, not all NODs are equal. Some are more serious.
Yeah.
Others are very de minimis and some are more serious. And therefore having that language perhaps, and I agree with Commissioner Benedon, having materially helps.
So are you comfortable with the language as originally?
Like to get the monopoly, what is it? Go past go and, I get to get that.
Jail free.
Yeah, to get that, you have to have that threshold to get that expedited review. So you're not in that choke point of it, and so I think we'd be splitting hairs if we take NOD because then what counts? What's a serious NOD? Who determines what's more serious NOD than the other one, right? So I think it takes the ambiguity out of it by leaving it in, but that's just my thoughts.
And some NOD, if I may.
Please, thank
Mayor,
you.
Some NODs could implicate concerns of suitability and ownership, right? They're not all that the security cameras at the wrong age.
Right.
And so I am comfortable with that higher threshold if you want the opportunity, and maybe that will even be a motivation to resolve NODs quickly.
I'm comfortable with that.
Okay. All right. So, Commissioner, I don't know if you're thinking about raising your hand or interested.
No.
Okay.
It's just a movement.
Well, I'm trying because sometimes.
May I ask,
Mr.
do we need motion like to the chair, to the executive director?
To provide direction.
Provide the intent of the board. What do you need us to do besides this definition?
I'd be comfortable, Madam Chair,
Thank you.
but I'd be comfortable if you'd like to make this motion, or if you'd like to just sort of indicate that there is a consensus that we are going in this direction, with of putting together an expedited process should folks not fall within these categories. I'm comfortable either way.
Commissioner Stebbins?
Do we need to incorporate this definition into our regs at a future promulgation round?
I believe that this language will be brought forward, and most likely, if this is kind of the intent and we're going to be relying on this, that may be a future reg conversation. But I think right now, giving staff the expectation of the board, we can start to create this process and the expedited process, so to speak. So again, I think that that's a potential outcome, but
This may also be part of, when we do get to red tape reduction regulations, that this, you know what I mean? This may be a longer discussion in terms of new regulations or changes in regulations. So, but I do think that having the sense, I don't know, I don't think that it hurts us to take a vote of the board. And again, whatever configuration of the new board is out there may decide this is not a good idea. But I think that it sends a strong message that we are trying to do everything that we can. Again, in the situation of, you know, the closures, the closures that we've seen, knowledge that there are 30 businesses that are in receivership now, anecdotal information that there's another 30 that we're getting a sense of the board. Again, maybe it's just consensus, I don't know, but I Executive Director.
thanks. Thank you, Madam Chair. Maybe one suggestion between what was just sort of discussed there is the motion to enter this into the red tape sort of product as a priority of the board. Might be a middle ground there. I'm not sure.
What's that? I'm sorry, what'd you say?
To take what you have here and make the motion that this is being entered in as the intent of the board into the red tape process.
Okay, Commissioner Roy, why don't you just read that motion?
It's on the fly, so might need some edits, but all right. Hold on. Okay, here we go. Want to read it?
Please do.
Move that the commission adopt the following definition of existing licensee in good standing for use in evaluating eligibility for streamlined or notice-based change of ownership or change of control review processes. Existing licensee in good standing means a marijuana establishment, medical marijuana treatment center, or other commission licensed entity that is of the date of submission of a change of ownership or change of control application, A, holds a current and active license issued by the Cannabis Control Commission. B, has no unresolved notices of deficiency, orders to show cause, or pending enforcement actions that could materially affect its license status. C, is in compliance with all commission reporting, fee payment, and renewal obligations. D, has substantially satisfied all previously imposed conditions of licensure, including operational ownership and corrective action requirements. And E, has not been subject to of a final commission imposed disciplinary sanction such as suspension, revocation, or monetary penalty within the preceding 12 months, unless specifically waived by the commission for good cause. The commission directs staff to incorporate this definition into applicable policies, procedures, and guidance materials governing change of ownership and change of control applications, and to apply it when determining whether a licensee qualifies for an expedited review.
Commissioner Stebbins, you have a question?
No, I appreciate the motion. I'm just wondering if in that last part, we would say commission directs staff to incorporate this definition into applicable policies, regulations, procedures, and guidance materials. Again, understanding what the regulatory process is, but I think putting this definition in regulation, I think it's good.
Yeah, in theory, it would be, but the commission's the only ones that can do this. The commissioner is the only one that can do it in regulation.
I think that whomever is in whatever iteration of the commission, that this can be put into regulation, but staff can't do that. Unless it's the working groups or something, but I think that keeping it cleaner might make sure that we're containing it to the authority that we're requesting them to exercise. Executive Director, did you have your hand up?
Thank you, Madam Chair. Yeah, I think the point I was making, I think between those two things was that the beginning of the motion is basically to say that this is the definition the board is comfortable with going into what will be reg processes that are coming, as well as then, you know, the associated processes that will come out of it that we'll have to be developing as staff. So that I think that the beginning of the motion indicating that this is going towards eventually a reg, I think is kind of the middle ground there. But I think overall, obviously there may be some questions on how we actually operationalize it, and we'll have to go through those. But I think otherwise, I think the intent is clear.
Okay, Commissioner-
My only question is, I like to put timelines and there's none in here. So 90 days, 60 days, or do we leave it open?
Because we may or may not be here to hold people accountable.
If I may,
Well, no, wait a minute.
if I may,
Yeah, please, no.
Mr. Executive Director, what is a reasonable ramp?
Yeah.
I get the 60 days.
I would say, given everything that we currently have as unknowns at the moment for everybody in the room, 90 days would probably make more sense if you're looking to add a time frame to it. And then again, I think we can start the processes, because we're going to have to develop and not just develop internally what the process is. There's going to have to be communications on the expectation of everybody will feel like they're a license in good standing. And so I think on a number of these items, yeah, I think the development of the process alone will be in the 60-day range. And then, you know, there's going to be a significant communication element to this, as well as what I think probably ends up becoming part of a reg process, although I think it can, again, the 90 days could be in there.
Should I just put 90 days, or do you want the date certain, like 90 days out from today's the 16th? So
Well, 90
May,
days
June,
from-
July,
yeah.
by July 16th?
Just put July 16th, and again, this can be voted again in the future. It's not acceptable. So again, I don't know if I'm saying this right way, but incorporating by reference the motion that Commissioner Roy just read, but adding to that language no later than July 16th, 2026. Is that accurate,
Yeah.
Commissioner Red?
It's not showing up when I do the edit. I'm just going to edit in a separate.
Yeah,
It's showing up. I see your edit.
Oh, I don't see my own edit.
I can see it.
I see July 16th. at the
Okay.
top there in that first paragraph.
Oh, should I put it to the bottom? Okay.
I think the
It's in.
works.
It's in.
Okay, it's good. All right.
All right, so the motion as read and written in the chat that we can see, but the public can't. Commissioner Roy, I'll entertain that motion to approve.
So moved.
Commissioner Stebbins, do I hear a second?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Bennett on.
Aye.
Commissioner Roy.
Hi.
Commissioner Stebbins.
Aye.
Chair votes aye, it passes unanimously. Okay, so I think we've kind of we dealt with 4, and I think we have discussed 2. All right. So, what I will take out of, because I want to be mindful of sort of the time and biology. Let us go, so ask the general counsel. So we had asked, and I had been told that we would have it by this meeting, a data use agreement form. I have been told that has not been completed. If the general counsel could come up and let us know why that is not completed on the time frame that we requested.
Thank you, Madam Chair. Yes, with respect to the data use agreement form, it is not ready for the board's review or consideration today. The reason for that, a bunch of different things, but mostly, well, chiefly I would say is really simply bandwidth. The legal department is understaffed to start off with at baseline. We have 2 attorneys who are just returning from leave at this point and just getting back up to speed. So we have been constrained in our bandwidth. We also have, as you're aware, 1 attorney who has been commandeered by the chair to act as purportedly as her personal attorney. So again.
Excuse me. Thank you. All right, thank you.
So
The answer is adequate. Thank you.
thank you.
So anyway, what I will say is this was requested by the meeting here. And I will note that the chair has requested from the general counsel because it sounds like a lot of stuff, including public records requests, are not moving forward at a timely pace because work is not being appropriately assigned. I had asked for a memo that outlined how legal work was being distributed, and apparently it's not being distributed in a fashion that allows work to get done in a timely fashion. So to that end, what I will do is perhaps we have a motion where we give the team enough time because I have been extremely concerned about open data. I'm going to tell you, I had a meeting yesterday with some folks who are very concerned about data fraud. I have been told by our previous director of testing who quit because he was prevented from saying the term data fraud. It is there. It is across the Commonwealth. It allows cheaters to cheat. It allows public health hazards to be presented to consumers. We have had our legal team prevent this from being spoken about by our former director of testing. We have had language removed from our report to the legislature that talks about the economic incentive. One of the conversations I had yesterday about why it is so important for us to have open data. And it was a very interesting analogy because there have been hundreds of thousands, if not millions of dollars that have been brought against grocery stores. And imagine when you go and you buy a pound of hamburger, you buy a pound, you think you're going to get a pound, but you're only getting 3/4 of a pound. You are not getting what you paid for. I have been told that the difference for some operators who are cheating, who are getting higher THC levels than science or logic would allow. It is hundreds of thousands of extra dollars that are going into the coffers of operators who are cheating. And so the people who are not cheating are begging for us to not only talk about testing fraud, but also resolve it. And so this is why I applaud the work of Commissioner Roy, who has really been leading on this issue of open data. And we have already received significant feedback from a number of different people looking at that open data, pointing directly at what appears to be financial trends leading to fraud. So this is probably the most central obligation that we have as commissioners to protect public health and safety. So I'm extremely disappointed. Again, I've asked to understand how legal work has been distributed. I have not gotten a memo on that. I don't believe that legal work is being appropriately distributed. So that is why it's especially disappointing to not have this here today. But Commissioner Benanon has an alternative because I think that this is one of those things that we must get done. It cannot wait, and the public cannot wait. Mr. Benanon?
I wanted to note that on March 12th, the board voted, I'm reading from the minutes here, of March 12th, Commissioner Roy moved to direct the executive director and commission staff to develop a draft data use agreement, or DUA, to permit end users to access de-anonymized identified data from the open data platform and to provide the draft DUA to the commission for review and vote within 60 days. So that would have been 60 days from March 12th. So is the team on track to do that within 60 days from March 12th?
Apparently they don't know. So,
Well, we're not there yet. And so I'm just questioning whether we need to take any action or whether the deadline that we already asked for on March 12th.
I had asked because of what has transpired with the legislature passing its bills, that this is not something that can wait. And again, I dispute how work is being distributed and this could be done. I was told not that long ago it would be done. And then at the last minute, I was told it's not done. So that's my concern. I was literally told that this would be done in time. I put it on the agenda. I talked about putting this on the agenda, and I was told it would be done by today, and at the last minute, it was not done. So if people are comfortable waiting that additional time, I'm okay with that. But I think that knowing that the public health and safety, that millions of dollars of added costs are being presented to the consumers in Massachusetts, I think that this is important that we move quickly. But if there is not support to move this more quickly, I'm okay with that. But I was told that this would be done by today's meeting. So, but anyway, Commissioner Roy?
To Commissioner Bennett point, do we have a sense that this is on track? Do we have a sense?
I don't at all. And this is, yeah, okay.
Is this on
Okay.
track?
Thank you, Madam
Yes,
Chair.
thank
But the document that we currently have is approximately 20 pages in terms of the going through a data use agreement, which we've been through with other folks in the past. So it's a complicated and significant document. In terms of early May for that deadline, given where we are currently with unknowns in the legislature, we have a lot on our plate for our legal team and others. But I think at this point, there is a document, whether that was ready to go for this meeting. The answer is it's not ready to go for this meeting. So
It's a document that's been drafted.
there have been data use agreements that have been reviewed, in the past, and we have that document now under review.
You've done this in the past.
We actually, we did go through a data use agreement discussion with UMass Donahue on the exclusivity report and ended up picking a different route due to the complications of the DUA that the UMass Donahue team was not comfortable with. So we found a different path forward with them. So yes, I mean, it's a complicated document.
That this was a compromise.
Mhm.
Commissioner Roy and I were talking, and there was pushback from our legal team that this creates a competitive disadvantage, which I disagree with that conclusion. And this was compromised to say, but to say how we would, and we do have models which could be amended, or maybe we should have been given some of those drafts that we've seen before so that we could take a look at them and discuss that. But that was never given to me. And I was told there would be one ready today. Right.
To
Thank you, Commissioner Roy.
Just quickly to
Please,
through the chair,
thank you.
the executive director, when you say you're reviewing is it reviewing multiple models, or do you have a draft for this open testing data? Is there a draft, or are you just looking at models right now?
There is a significant amount of work to be done on the draft that would be for this particular purpose. And the intent, so everybody's aware, the information currently is up online on our open data platform. Obviously, people have been using that. We've had discussions on it. The question of getting access to an end user that is looking for that to be de-anonymized would be the compromise, as the chair noted, would be the DUA, would be the process to shift the liability to the person who is requesting the de-anonymized data. So that document is a sizable document, is not ready for today. To the question of whether that will be ready in early May, I certainly, again, want to hit all of these timelines. As we've noted on a variety of different meetings, we have been pumping out a significant amount of work for these meetings. And so while I understand the frustration that one item is not ready for this particular meeting, I also would applaud the team who has been hitting all of these other milestones on behalf of the board.
That we ended the debate about de-anonymized data and greater transparency because we were told that this was the solution, this was the compromise. I would have preferred a draft so that maybe we could talk about it. Maybe we could see what some of the weaknesses are. But I literally found out at the last minute that it was not going to be here. So again, I reject the fact that work is being appropriately distributed among attorneys. I already raised that question. So I don't know if this requires further conversation, but I will just say that I grow skeptical because I have asked pointed questions about transparency. And I am told that we can't be more transparent because we're worried about liability. Yet I am pointing out today that I think that we have serious concern about future liability for the commission if we do not do more to provide transparency, to protect the public health, to protect consumers, and to ensure that we hold licensees that are gaming the system and earning money and putting honest competitors out of business. So that is central to what we can and should be doing. And I am just concerned that the head of our legal team has on multiple different occasions appeared to be in opposition to transparency. So I thank all of the people, especially the independent testing labs who've been reaching out. I thank the amateur scientists, the real scientists who've been looking at some of the data that's out there. And I do think that there will be actions, and I will, and again, I don't know if anybody has any others, but one of the things that, I did want to raise here, because I do think that it's in scope, because it deals with the overall, problem with consumers purchasing items that have, and again, I use the butcher model where you think you're buying a pound of hamburger and they put the thumb on the scale and you're only getting 3/4 of a pound. Commissioner Roy and I had a conversation with the Attorney General's office. And one of the items that we raised is that when an independent testing lab or one of the operators that is attempting to seek out independent testing labs that are not providing us with honest data, especially as it pertains to THC, which impacts price, that this potentially is a violation of Chapter 93A. And I don't think that it's necessarily in scope right now, but it is something that I will be sending a letter to the Attorney General after this meeting today to request. And again, we met with the folks from the Consumer Affairs, that really is when individual people reach out to them. They've had approximately 20 persons that have gone through their website or others and have raised consumer protection issues with them. And about 15 of them have been like, they advertised $18, they charged me $20, something like that. And then they rectified it or addressed it. There were another 5 that had more to do with potential testing fraud, inappropriately labeled products. And what they do is there is no direct communication with the commission. It is a soft referral, as they explained, where they suggest to the consumer that they reach out to the Cannabis Commission. So I will be, after this meeting, I will be sending a letter to the Attorney General and raising this as a broader consumer protection need, that when an ITL signs a certificate of analysis and that does not accurately reflect what is contained in the product. Again, there can be mistakes, but when there appears to be willful manipulation of certificates of analysis, and this was Commissioner Roy's thought, I believe that the Attorney General should be protecting the consumers of Massachusetts. So I'm just letting my fellow board members know that I'll be sending that letter, at the end of this meeting. Are there any further questions and comments about the data use agreement form? Commissioner Roy?
Thank you, Madam Chair. I just like to bring it back to Commissioner Benedon's point. That motion language was voted on unanimously on March 12th, 2026. I will read the motion language. The commission approved the motion to direct the executive director and commission staff to develop and draft data use agreement or DUA to permit end users to access de-anonymized identified data from the open data platform and to provide the draft DUA to the commission for review and vote within 60 days. So that would bring us approximately to May 12th. So my question through the chair to the executive director is, we don't know what the future portends for the construct of this board, but could we have a public assurance that it would be done in respect to this motion language and the intent of the board by May 12th, unless the new board rescinds that, this intent will be honored, I guess is my question.
Executive Director?
The intent is to get the DUA up online May 12th. I'm happy to say that will be our goal. To commit to it, I will do my best. I don't know what else to tell you. Yes, the intent is to have the DUA available. I'd like to again reiterate all of the information that's currently online is the majority of information with the exception of the de-anonymized section. So the information is being used for the public health and safety point that was made earlier. The intent is to have the DUA up and available to those folks who are requesting the de-anonymized data, to have the agreement to say that, you know, this is the appropriate use of the data, or that they are taking the data with the de-anonymized and understand the liability that exists for that. So that is the intent.
Okay, so and I understand your precaution to indemnify the commission, and I understand that, and with respect to that, and so I appreciate the public assurance to honor the intent and the will of the board, unless the new board comes in and has a different intent. Then obviously that's a different story, but I appreciate that, and
Commissioner Wright, if I can say, votes already been taken.
And they have till May 12th.
Right. So I believe, again, it's not what, this has been a vote that's been taken by the commissioners. So I just get worried that it is our intent to follow that vote. It's just an intent. I'm just clarifying, because I'm losing the thread here.
We are looking to get the DUA available to those folks who are looking for the de-anonymized section of the information that's currently up on the website. And that is the intent that I'm talking about, of us following through with the motion of the board.
Okay, so you're saying that it will be up by May 12th?
Again, we're discussing the capacity issues, but that we are going to do our best to get that up online by May 12th.
Okay. Hang on. All right, so it is 12:25. Executive Director.
Could I just ask, just for the record, so I know Commissioner Benedon had spoken with one unit at the AG's office, and then we were going to set up commissioner discussions. Was that with the card unit specifically, just so folks understand?
That was not the correct unit for us to be talking to.
Okay.
That's small board. This Commissioner Benedon.
Yeah, so Commissioner Stebbins and I initially had a very brief introductory meeting with the Consumer Protection Division, which is more the investigation and enforcement division.
Right.
All four commissioners in 2x2s, maybe it was 2 1-on-1, met with the CARD, the consumer advocacy, as Commissioner, or as the chair noted. So it may be that if we were to follow up again, it would be with the team that Commissioner Stebbins and I initially met with.
Thank you.
I hear what you're saying, but when we were talking to them, it did not feel that they had that the 93A, and you would know better than I, that 93A consumer protection, that I think that this is now serious enough, and the potential for a class action lawsuit is becoming more real every day, that I think that we as I am just saying that this is something that I intend to do. It's not an action of the board. I'm not asking for a vote, but it was after talking with the same group that you talked with, and it just, they hear issues of potential THC inflation, and all they would say is call the commission. So I don't know if people are or they're not. And maybe we need to wait for the anonymous tip line. I don't know. But I do think that all of the evidence that I have received from operators, from licensees, from businesses that are not facing bankruptcy, facing receivership, are telling me that they cannot compete with cheaters. We recognize that there's a significant problem, public health and safety. So when we met with the same group that you met with, it did not feel like that was the appropriate level at the Attorney General's office to make sure that we're protecting the public. Commissioner Roy.
Thank you. And so this came up, I think last meeting with the update on the enforcement actions. And I want to thank our acting CIE, co-acting CIE, EC, Tim Gooden. I did bring up the issue of 93A with consumer protections, especially around certificates of analysis. And perhaps in hindsight, it could have been applied to Assured, but I appreciate Enforcement Council saying they will apply this lens moving forward, if appropriate around that with 93A. So I do want to recognize that, and that is the lens, perhaps if appropriate, we will be applying if we do suspect that there is consumer fraud to working with the Attorney General's office, which has not, I don't think we've taken that step in the past.
No, we haven't.
But if there is potency inflation and folks are paying for 32% THC, when in reality it's 20 or 20%, that is consumer fraud.
Right.
And so it should be treated as such. So I just want to thank Enforcement Council and, and hopefully this is a lens that we will apply when appropriate moving forward. Thank you.
Second Director, are you hearing these same anecdotal stories of you? I mean, obviously we had the issue with Assured and there was a reason that there was a serious and substantial payment that was made, a fine, and their license was suspended for a while. Are you looking at the trends that we have seen from the open data and taking any action on them?
Thank you, Madam Chair. And noting obviously that I've joined you and Commissioner Roy and others on some calls for that effect. And obviously we've had our individuals as well. Yes, I mean, obviously the team came about the enforcement action that you referenced by looking at the metric data, also going in and looking at a variety of other data, including data that is not always input into metric, and that comes through LIMS systems and these types of things. So there's some sections that we're looking at right now of how we maximize, and obviously you've discussed in the testing protocols as well, how we can maximize what we can do remotely and identify the areas of which lead into investigations. There's also, once those are triggered, then there's the investigations that follow. So I guess what I would say is there are a number of items that will be coming in front of the board in the future that have relation to this, but also, we are looking for, within those testing protocol change recommendations, ways in which we can maximize how we can flag things even sooner in the process. And then, to your point as well, the action that was taken is not the end of the line that was taken over the summer. So we know that there will be other actions taken, and we want folks in the industry to understand that we are looking at that. And that, again, just goes back to my point, just to kind of close the loop on the anonymized versus de-anonymized. Totally understand the interest in having the de-anonymized data. I just want to make people aware that the information that's up online in the open data platform that is de-anonymized, the nature of each of the labs is obviously known to the investigations team. And so while I understand the interest in it, I also want to make people understand that, yes, we are looking at this, we're taking this very seriously. And while last summer was a very significant step, that is not the end of the line, I think, to the point that you've made in the past.
So the team is actively looking at that data because I know obviously 30A, we have to be, and everyone has due process rights and data is data. But, so is that coloring some investigative work right now?
Yes, Madam Chair. And I think the other thing I would state too is a lot of work coming to the board as well will be based on and kind of in concert with testing protocols in terms of the enforcement actions that are outside of the public health and safety realm, more in the consumer protection realm. Enforcement Council staff has been working diligently as well with the investigations team and others, and review by legal in terms of setting thresholds to bring to the board for regards to the THC that is presented on a product. Again, outside more of a consumer protection issue than a public health and safety issue, but one that we take very seriously as well. So again, sharpening all the tools at the moment. The board has been very active in that as well. And yes, that data that is available online is data that is also available to our team. in the de-anonymized fashion.
Thank you. All right, thank you. All right, so unless there are any further questions or comments about this, again, we've already taken a vote. So the intent of this board is that this should be made available publicly by May 12th. So just asking my fellow commissioners, it's 12:30 now. I am wondering if we take about just shy of 45 minutes, if that is a long enough time to grab lunch, 12:15. Does that make sense? And we can come right back.
I'm just wondering,
Yeah,
Madam Chair.
1:15.
just a
Do you want to?
quick housekeeping issue, because it ties into what we just, like, we had consensus on establishing the testing task force as a
Yes.
standing permanent body, but we forgot
Let's
to
do
vote
it.
on it. So if I may, that would tie that
Entertain
together.
a motion, get that done. Yep.
Okay, move that the commission direct the executive director to take the necessary steps to establish the testing task force as a standing permanent body of the commission. The permanent testing task force shall include the chief of research or their delegee and the director of data analytics or their delegee as members in addition to its existing composition. Further, the testing task force shall expand its scope to include an examination of cannabis testing yields, including but not limited to dry, wet weight, for the purpose of identifying and addressing potential instances of fraud. Additionally, the testing task force shall develop and present to the commission within 60 days a standing operating procedure to initiate auditing of ethanol for the purpose of detecting inversion or other related anomalies. So moved.
Thank you. Do I hear a second, Commissioner Vandana?
I have a comment.
Oh, please, thank you. Go ahead. Sorry. Beg your pardon.
This vote is not something that I support, and the reason for that is, although we discussed it previously, and we have been so far moving forward and continuing to do work without regard to the changes that may be coming on something like this, that is a policy decision, requires devotion of resources. We've just heard from our executive director about how much is currently on the team's plate and how much more is likely to come. And given how close we are to a likely transition, I don't feel that this is the time to formally approve and require something. And I would be inclined to leave this as a policy decision to a future iteration of the board, which again is imminent at this point.
Commissioner Roy?
Yeah, and thank you, Commissioner Bennett. And I hear your point. I just feel this is a public health issue. And the 60-day ramp would allow enough time if the new iteration of the board feels it's not worthy to allocate resources. We had consensus. It was just we didn't vote on it at the time. So if we, had voted on it, it would have already been in the books. So I'm inclined to move forward with it, knowing that there's 60 days and the new iteration of the board could say, we don't feel that this warrants an allocation of resources. But I sit in the public health seat. I have been consistent on advocating for consumer protections, open data, transparency, and I applaud the work of the testing task force, what they were able to accomplish in a matter of 4 months. And I feel it's critical that they need to be a permanent body. And I'm hoping this motion language, which would establish that, would also help them gain resources. As we heard, many of them are doing, they have their regular full-time job in addition to the testing task force. So, and with the addition of research and data analytics, I think it would be incredible asset. So I understand if the vote goes down, I just feel on principle, I need to continue and be consistent. So thank you.
Thank you. Executive Director.
Thank you, Madam Chair. Not here nor there on the motion itself. Just wanted to note, as we have done, the board has obviously been pushing this as well. Within our expansionary request for FY27, there are funds in there that would have the specific intent of increasing our ability to leverage the excellent work that Commissioner Roy noted from the the non-permanent testing task force that was started last year, and we just discussed the outcome of. So just wanted to note as well, obviously, this is in the request that the board has approved. This is something that we know that we need, and we need to continue to make sure that, Commissioner Roy's point on its importance for public health and safety lands with the legislature in terms of the final budget. So just wanted to note that. Thank you.
And if I may, I think it aligns with the legislature because they've advocated that we prioritize worker safety. They've advocated we shall establish an anonymous portal, and so this aligns very much so with a focus on public health. I also want to thank Armin and Tim, our co-CIEs. They flagged for my attention that originally we had said test the ethanol, and no one here really has, that I'm aware of, has a hazmat license. So based on that consideration, I modified testing to auditing, so they can audit it when it comes from out of state. I think is more doable for the commission. So I heard them and I appreciate their feedback, and I did incorporate this. So I just think it's very important, and thank you, Mr. Executive Director. You see the necessity for this to be permanent as well, and I appreciate that. Thank you.
So we can just, I'll second your motion. We can call the roll, and I understand people.
I know, and I respect that, and I understand.
So that's fine. So I'll call
Yeah.
the roll. Commissioner Benedon.
Yeah.
Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner O'Brien votes aye. Vote
Okay,
passes
thank
3-1.
you.
Thank you. And thank you.
Yeah, thank you.
All right, so it is, all right, so it is. Yeah, so we will come back. All right, so we will come back and we will. Do we want to take a vote publication of the receivership reporting form?
No,
That?
I need a
You
minute.
want to wait on that? Okay. All right, okay, so we will take a break until 1:20. Is that enough time for everybody? 1:20? All right, Commissioner Roy so moves that we take a recess until 1:20. It's seconded by Commissioner Stebbins and is unanimously approved. All set? Yep. Thank you. Yep. All set, everybody? Everybody? Right, so we'll go with number 10 out of the gate here after lunch, and received a number of, obviously this was something that was already on the agenda, but with the passage or potential passage of the legislation enacted by the House and the Senate recently, pending the governor's signature, one of the issues that was raised to us is that obviously 420 is a big day for sales. The language of the potential statute is very clear as it pertains to flour. But as it pertains to things like edibles and concentrates, it literally reverts back to prior statute that requires the commission, and that is assuming that that needs to be some sort of approval by the board, that we would establish what those levels are. I want to thank some of the folks from Dutchie and other places, Dr. Jeff Rawson, for providing us some information, because initially it was thought, and I also want to thank Commissioner Roy for having raised this with the executive director either earlier in the week or last week, that this would require, this is not just something that just goes into effect with the statute. It requires something additional for the board to do to define this. And also just putting out a memo that references a regulation, I think it's going to be very confusing for a number of licensees. So to that end, I know that Commissioner Roy has prepared language that will help clarify what we should do. You know, there were some questions because it's formulary and looking at, you know, THC and you know, whether or not this could just be a simple, just a doubling. If the legislature had just wanted to double, they would have just put double in there. So it does require us as commissioners to take some additional clarifying actions. So anyway, I will ask Commissioner Roy. She has put together some language that I think makes sure that we've dotted all our I's and crossed all our T's, and we're giving clear direction, because in speaking with the representatives of one of these point of sale businesses, they noted that this can be done at the turn of a switch, so it is not a manual process on Monday, but that they do have to do some work and some coding to make this turnaround very quickly. And so again, I apologize because I had hoped I'd actually planned on getting to this earlier, and I should have taken this out of order sooner. So anyway, Commissioner Roy, if you want to share some of the work that you've done and how we hopefully can solve this quickly.
Yeah. Thank you, Madam Chair. And I know licensees are, as you had stated, they're very anxious to be able to go from 1 to 2 ounces in the daily purchasing limits. We all know 420 is the biggest cannabis holiday, if you will, which is rapidly approaching. You know, and I guess the question here is where the board's comfort level sits, simply a bulletin or through an administrative order. And bulletin does not have the same force and effect or binding enforcement that a bulletin. And why would that, you'd say, well, the statute supersedes the reg. Why would you bring that up? Because the statute is not applicable to 935 CMR 501. And so we do through an AO, through the executive director, this is binding.
Administrative order.
Yeah, sorry, administrative order, where if there are enforcement actions needed to be taken for an MTC who may be in violation I just think this puts us on a little more sound legal footing than a bulletin. So I did share, and I know people want the equivalency outlined for edibles and concentrates, tinctures. So that is also highlighted in the motion language and would be in an administrative order issued through the executive director upon signature of the governor on the House bill. So I just think that because it's not applicable to medical, I think a bulletin, although we've issued many in the past, I just think an AO gets us a little more on legal sound footing, and we need to be, there are still a lot of questions. So we want to be expressly clear in whatever communication we send out, what the equivalency is, and so there's no ambiguity at all. So personally, I'm in favor of an administrative order, but it's where the board's, either way, something needs to come out upon signature.
Again, I think it's more than just announcing, because that is not
Right.
what the statute, you know what I mean?
Yeah.
It's,
And to your point, we have formalized motion language today, which enumerates all of that. That will give clear intent to those listening, such as Dutchie, where this is going, and upon signature that an administrative order would take effect. To your point, I know there's work that needs to go into a point of sale system. I think Metric is, from my understanding, Metric is good to go. But I know licensees are anxious, excited for this opportunity. It's the intent of the legislature to see them be able to do transactions for 2 ounces. And I just think we should have something on sound legal footing and be expressly clear at the same time. So thank you, Madam Chair.
yeah, thank you. And again, I think the question was, the language, and again, I don't have you probably in front of it, but the statute, the soon to potentially be statute didn't just say 2. And there's a reason, because that references, other language within prior statute and also requirements of the commission. So I think that the administrative order is safer, but also just stating what it is, I think will be easier for licensees. So Doran, Executive Director.
Thank you, Madam Chair. Obviously, we had been preparing the bulletin, which you have a draft of. I think that we can certainly take that and easily reformat into an administrative order if that's the intent of the board. I'm comfortable in either scenario personally, but obviously the discussion can continue, and I'm happy to discuss that if there's any questions. I think Commissioner Roy specifically highlighted what I think we want to make sure there's no confusion on, which is that this is not something that we are preempting. This would only go into effect with the governor's signature, so we can try to provide information ahead of time so that people can prepare. But ultimately, we'll have staff prepared to send out additional information should this be signed over the weekend. So I'd like to first thank staff who have obviously prepared the bulletin that you were provided yesterday, and we'll update that to include specifically enumerating the application of 2 ounces to other products. And then again, just to kind of reiterate here, the medical program has a different limit. And so what we would be putting in there is specific to the adult use. And then again, at any given point, if the governor will sign this, we would be looking to get this out immediately. So if that ends up happening on Sunday, which appears to be the deadline, then theoretically we would be sending that out to the industry on Sunday that has been finalized, and get that ready so that the POS systems are live on 4/20.
Take a vote today. I think that, and again, I unfortunately left my file folder in the other office, but the equivalence, Commissioner, do you have that?
In the language.
It is in the language, okay. So again, rather than directing people to look up, regulations, just to make sure that we're clarifying the grams, and you know what I mean? So it's just much easier for people to understand. So do we have that?
So I'll also thank CTIO and others who had done a lot of prep work with a lot of these platforms ahead of time. So a lot of staff getting prepared to work on the weekends to make sure that all these things can be done, and I appreciate that. And also the staff who put work into this to date. Thank you.
Thank you. Commissioner, do you want to read that?
Well, I'd like to hear.
Oh, sure. Well, I'm just saying, do you want to
Yeah.
read it so people
Oh,
can
I
ask?
see.
Yeah, why don't you read it so people
then-
have something
sure.
to, I mean, again, it's in the chat, but I, just
Of course.
because the public has to file a public records request to see this, I just want to make sure that people listening or watching know what we're talking about.
Okay, thank you, Madam Chair. Move that the Cannabis Control Commission direct the Executive Director to issue an immediate administrative order number 6, authorizing the daily purchase of 2 ounces or less of marijuana or the equivalent amount of marijuana products as determined by the commission, consistent with Massachusetts General Law, Chapter 94G, Section 7A1, as amended by House Bill 5350 in the commission's equivalency and potency standards under 935 CMR 500-143. For purposes of this administrative order, 2 ounces of marijuana flower shall be equivalent to 10 grams of active tetrahydrocannabinol, THC, in marijuana concentrate, including tinctures, and 1,000 milligrams of active THC in marijuana edibles, and that such equivalencies shall govern the calculation of combined dry weight equivalents for marijuana concentrate and edibles in retail purchases, effective immediately upon the governor's signature, enacting House Bill 5350 into law. This administrative order shall apply solely to adult use regulations under 935 CMR 500 et sec and shall not be applicable to medical use regulations under 935 CMR 501. Thank you.
All right, Commissioner Benedon, you had your hand up first, and I don't know if you're ready.
Sure. So I just wanted to clarify primarily for the public, when we have used administrative orders in the past, I think we have issued 5 or 6 administrative orders, 5.
I
So
believe.
this would not, oh, I see, this would be a 6. And so this is not something done frequently. I know one of them, I think the last one had to do with testing. Does anybody have at their fingertips kind of a?
Yeah, so I believe 4 was the duplicate samples and pending duplicate samples. I think 5 was the certificates of analysis off the top of my head. I could, yeah.
I mean, what? Commissioner Stebbins, do you have any questions or comments?
Yeah, I had a question, but I think it's covered in the motion.
Okay, can we do this that quickly?
One
Commissioner
other
Benedict?
question. So the intention is that the executive order would issue, that the executive director would issue the administrative order now.
Well, I was almost going to strike immediately. That's what I was going to ask you about that.
Can I ask why? I know he's already pledged to work over the weekend.
I'll get rid of immediate. I think that's right.
But why couldn't we do that? Because it states pending passage of the bill.
Oh, I see what you're saying.
See, I don't know why we would wait, because it's the condition precedent is the bill being signed by the governor. And so the sooner he sends this out, and that's ultimately what I thought I was hearing, is that they want to hear, they want to know, and they want to know, because as I read that bill, it's not just turn it on, it requires an action of a commission. So we're taking this action, and then it's conditioned upon the signage of this bill. So,
Yeah, so
I feel like, again, he's pretty good. We have to take action, and I don't see why we would wait, because then it just allows him to do it. If the bill gets signed tomorrow, if it gets Saturday, you know what I mean? Whatever.
Oh, I see. If you have, okay.
Go ahead.
my
Commissioner Benjamin.
concern, I think, is just in the language. So in the 2 paragraphs that you just read aloud and that we're looking at on our screens.
Yes.
The first paragraph says issue the administrative order immediately authorizing the purchase of 2 ounces of marijuana. And then the second paragraph says the equivalencies and says the effective immediately upon the governor's signature, suggesting that the equivalencies portion is
I see what you're saying.
contingent on the
Okay.
governor's.
Yeah, that makes sense.
But it makes it seem like the 2 ounces is immediate. And
Okay.
that's not the intent.
And it's not the intent. So,
But that's just a draft.
so do you have a friendly amendment?
Yeah, so let me,
Is the 2 ounces is immediate? We're not weighing in on that.
no, it's not immediate now. It's
Until she signs, until the
Until it's
governor upon signature.
right. But the way this is drafted is, as I read it, is telling the executive order right now, like today, issue an
Yeah.
immediate administrative order.
I agree with Commissioner Benedicte. We want to do the friendly amendment?
We'll do that.
Okay, Commissioner Benedicte.
Can I just ask the question, because, so are you saying that if we issue this administrative order, that it goes up to, we have no power to?
No, that's not what she's saying. The way it reads, it's almost like, prior to a signature, we are, authorizing the daily purchase of two ounces. And then
Okay.
the signature is
I
contingent
get-
upon the edibles.
Okay.
So it's, yes, it's just wordsmithing it, so it's a little more clear.
Yeah.
So thank you, Commissioner
Thank you.
Benedicte.
Okay, I was misunderstood.
Yeah, it does need to be wordsmithed a little bit.
Okay.
And just offer,
Executive Director?
since we have, and we'll have two versions here, perhaps the bulletin to go out notifying folks that this would be coming would be the proper thing now, to not be ahead of the governor. And then should a governor's signature be ready, the administrative order would then go out at that point. So that, I mean, we have it in both forms, so it's not a heavy lift. That the administrative order wouldn't go out, and because there's the governor has the right to veto.
The governor has the right to veto, and she could also say, I don't like these increase in.
Right, so if we do a bulletin now saying, should this come at some point, we will be issuing an administrative order at that time. That may just be a more appropriate, and we have it in both forms, so we can do that easily. It just might be a middle ground.
David, I knew you've been working on this, and I knew you were the first one to raise it, so I leave it.
Yeah.
up to you.
Let's give Commissioner Benedicte a minute to wordsmith. And, so when would the bulletin, if I may, Madam?
Please.
When did you anticipate a bulletin? Today, tomorrow?
So the issue, Madam Chair, the issue has always been that we can't be ahead of, and obviously we've discussed that today quite a few times. So ultimately, we don't control whether or not this bill passes as currently written or when it does, although we know that there's a general deadline on the 19th. So we'll be prepared to send out something on the 19th when it's official, but we could, I guess, to the conversation going on now, send the bulletin now saying that we are tracking this is the anticipation. If it is signed with this language, then we would be issuing an administrative order, and then that could also be ready to go over the weekend if signed as currently written. So that we're not issuing an administrative order prior to a governor's signature, but that the administrative order would be then sent at the time of the signature. So that we're giving folks what we know at the moment by a bulletin, but not providing an official administrative order until such time that it's appropriate to do so.
On signature.
Exactly.
Are you comfortable? I'm okay with that.
Commissioner Stephens?
Yeah, I'm comfortable with that as well. Just saying this could happen. We can explain the deadline by which the governor has to sign the bill, and if it does, please be on the lookout for an administrative order.
But, so I just want to clarify. So we are going to do an administrative order. Okay. But we're going to do both.
But not to preempt the signature, we're just saying anticipate this,
Yeah.
gives, and then upon signature, you would issue the administrative order. Is that accurate?
Correct. They'll both be ready to go, but the administrative order would not go until and unless a signature. So that the bulletin would say this is how this would be applied, so that if they want to plan ahead, but that is not an authorization. And then the administrative order could then theoretically would be the authorization to say you were notified, so you could prepare, but this is the actual authorization.
If I may.
Okay, go ahead. Sure.
I think to that point, you need to be emphatically clear. My only concern is people would misconstrue the bulletin as an authorization.
Right.
So that needs to be like,
Well, then the first sentence should be only upon or about.
Yeah.
But it's also
Yeah.
not just the bill. Because she could. This is just trying to think. I'm gonna call my friend Stevie James for procedure, but I don't remember, but would it start with upon the governor signing the bill? Is that the language you're thinking of? How do we?
for the bulletin,
I'm talking, well, I'm just saying, I think that what you're saying is that the bulletin might, it's almost a moot point, because it's really who we're talking to is is Dutchie, because right now there's like a governor, there's like a, not governor, but you know, like a car, you can't sell more, right? And so it's only, am I wrong?
Well, if I may,
Yeah.
Dutchie does have the majority of the point of sale, but there are other companies.
And
And
just-
so
it's just-
it's
yeah.
talking to all of that
Talking to all
universe.
Still, yeah.
Yeah, all point of sale. So I think we just need to be expressly clear, and a bulletin could be that first salvo to say, this is what we anticipate coming, and this is, but it's not an authorization to begin immediately. It's upon,
But my point is that it's a small audience that we're talking to.
not really. No, because it's consumer, I mean,
No, but my point is, it's, the point that was raised is that this cannot be unilaterally, it's like you can't get around it, right? It's point of sale, it will stop you in store from purchasing. Am I?
but if we're unclear,
Oh, no,
it could lead point of sale in a, down the wrong path, and we don't want to do that. And we want to be
Okay.
expressly clear to
Okay.
point of sale, like
Okay,
the bulletin will lay out, this is what we anticipate. This is not an authorization to begin today. And then it's upon governor's signature, the administrative order will go out. I think it just kind
I
of,
think we're saying the same
I
thing.
think we
mean,
are.
Yeah, we're saying the same thing, okay. But
Sure.
Mr. Stebbins,
Thank you. Just a couple of quick questions. Gets back to point of sale operators. We obviously know Dutchie has the preponderance of the marketplace, but some new players have come into the marketplace. Do we know for sure that we have connected with all of the point of sale operators or point of sale platform operators?
Executive Director?
Thank you, Madam Chair. Yes, this has been in the works. The government affairs team flagged us right out of the gate. So we've been working on this. I think ultimately, again, the trick here is that we're preempting theoretically the decision of the commissioner. So we're just trying to walk that line. The bulletin and the plan to get information out on the weekend was to avoid that. I think I certainly would flag an administrative order to go out prior to a signature, I think is problematic and we should avoid. I think the bulletin that we can, if the board's desire is to switch that to an administrative order, we could be prepared to do that quickly. But I think, again, the point here being people are looking for how we'll apply it, which is a relatively easy mathematical extrapolation of 1 ounce to 2 ounces, not just for flour, but for the equivalencies. And then, but we would want people to be clear on that as quickly as possible, but ultimately not send out until such time the governor has made her decision that the order is in place and people can update their systems. Again, there will be other ways that people would be able to do this. If they don't configure their systems, they could do 2 orders of a maximum 1 ounce, et cetera. But what we'd like to do is, if people want to plan ahead and the governor signs that we would not send out the formal notice that it's been signed until such time that it is actually signed, but that we could give people as much of a heads up as possible without preempting the governor's decision.
Mr. Stebbins?
Is Commissioner Roy, is there a concern from what I'm hearing you say, folks might take a bulletin as kind of
my
green
concern
light?
is you want something that's enforceable, and we know this doesn't apply to medical use regulations. We also, and we also want to be on sound legal footing. Without going down this rabbit hole, we know there's a ballot question. We just want our licensees to be on sound legal footing as well. So I think the safest legal route is the administrative order in conjunction with the bulletin to provide clarity, and the administrative order, which is more legally binding.
But I also think it was clarifying what the equivalencies are, and that's why we were talking.
Yeah, that was,
I mean,
that needed
the whole point is
clarification.
The language was it's silent in the statute, and it tells us, the commission, it tells the commission, which is us, the board,
Yeah,
to act. So that's where I get a little bit concerned that if we don't do something official, I mean, again, we can direct them to, a bulletin can be sent out, but we need to, I'm just not legally sure that a bulletin can just go out unless we actually take a vote on something. I may be wrong. I don't know.
it had bulletin.
No, but you know what I'm saying? I mean, because it was, the equivalencies was not defined in the statute.
It was not.
Is defined in the statute. And then it says equivalency as defined.
By the commission.
And one of the questions that you had raised is it one-to-one? And we were just trying to make sure that whatever that equivalency scientifically, whatever, is appropriate. And
Mhm.
is it just 1-for-1? So just double it? So that was a question that we were
That's right.
raising.
Right.
So, and just not leaving people to go and look and read the regulation to.
That's right.
figure out
I
what that
think
means.
the more expressly clear we are, I think it's to the industry's benefit.
Yeah, the flower is gonna be easy to figure out. This is just requires a little more finesse. So do you have another question? Are you comfortable with that, Commissioner Stebbins?
Yeah, what I was trying to suggest is maybe issuing a bulletin. I do like the approach of the administrative order for the reasons that you've outlined. The bulletin going out first, kind of signaling our intention. If I heard you raise a cause for concern that might be confusing to some of our licensees, right? We've cautioned everybody before, don't do this until the regulations are promulgated. I'm wondering if it's something less formal than a bulletin, that kind of notification might come from the ED. And then we follow up with the administrative order if and when the governor signs that provision of the bill.
I think
I don't know how that the ED would feel about that, but
I think that makes sense. I mean,
I think it makes sense.
Commissioner Bennett, she's.
Yeah. Great, thank
Sorry,
you.
could that be repeated? I'm not sure I caught it all.
Go ahead, Commissioner.
sure, in just having a conversation about a bulletin, hey, this could be coming to you on Sunday to be followed up by an administrative order. To move away from any confusion a bulletin might convey, if there was a message simply from the ED saying the commission is prepared to, however you want to word it, but essentially a message coming from the ED on behalf of the commission to say, if this provision of the House Bill, House 5350 is included, anticipate that we would be issuing an administrative order to allow for the increased amounts of cannabis available for purchase. Again, stepping away from confusing people with a bulletin, then administrative order, just more of a general pronouncement of what our licensees and our point of sale platform folks might expect over the weekend.
Understood.
Commissioner Bennett?
Thank you. So a question for, through the chair to Commissioner Stebbins, are we proposing not a bulletin, but something more like a press release?
I'm saying for the motion you have drafted, it would be an administrative order and not a bulletin.
Commissioner Roy?
Rich, I'm saying, in lieu of the bulletin, that communication could be a press release. In other words, the executive director would issue a press release in lieu of the bulletin to avoid that possible confusion. Is that the communication, would you be okay with that communication, a press release?
Or however we want to do it, I turn to
Okay.
the ED for what he can do and what he is that, what he would prefer.
Executive Director?
Thank you, Madam Chair. Yeah, again, I think we'll bulletin press release, we'll obviously be very careful in any instance where we're preempting a decision that's the governor's, and we can message that out so people understand how it would be applied, and note that nothing is effective as obviously would be done prior to signature until such time that there is a signature, in which case there would be official communication at that point.
Yeah, so
And if you could.
I just sent language. Did I read it aloud?
Please do, I guess,
Okay,
as the
I
public.
was still working on it, you know, we're ready to look at it. Move that the Cannabis Control Commission direct the executive director to issue a bulletin. Although we can decide if we want that to be something else.
A press release? Well, all right, why don't you just read it
Okay.
and then we can.
Issue a bulletin, but that's a placeholder word, no later than a date and time whether that's today or
Okay.
tomorrow morning. Clarifying that if and when the governor signs House Bill 5350, increasing the daily purchase limit of marijuana flower to 2 ounces, a further administrative order will be forthcoming. The administrative order will provide that 2 ounces of marijuana flower shall be equivalent to 10 grams of active THC and marijuana concentrate, including tinctures, and 1,000 milligrams of active THC and marijuana edibles, and that such equivalencies shall govern the calculation of combined dry weight equivalents for marijuana concentrate and edibles in retail purchases. Further move that the Cannabis Control Commission direct the executive director to issue an administrative order number 6 immediately upon the governor signing House Bill 5350, authorizing the daily purchase of 2 ounces or less of marijuana or the equivalent amount of marijuana products as determined by the commission, consistent with MGL Chapter 94G, Section 7A1, as amended by House Bill 5350, and the commission's equivalency and potency standards under 935 CMR 500.140 sub 3. For purposes of the administrative order, 2 ounces of marijuana flower shall be equivalent to 10 grams of active THC in marijuana concentrate, including tinctures, and 1,000 milligrams of active THC in marijuana edibles. And that such equivalencies shall govern the calculation of combined dry weight equivalents for marijuana concentrates and edibles in retail purchases. The bulletin and administrative order shall apply solely to adult use regulations under 935 CMR 500 and shall not be applicable to medical use regulations under 935 CMR 501.
Okay, so the only question is, do we want to include bulletin?
That's the question.
I don't know if we need to do both. I mean, I think that if we, and actually,
How about a public communication?
yeah.
Okay. No later than tomorrow. Yeah, no later than April 17th. No, yeah, 17th, 26th. And day.
I mean,
Midday.
I don't think midday because,
Yeah.
I mean, my sense is that a lot of them are teed up to do this. I think that they're going to be listening to this, and once we take this vote, they're going to have the ability to go, okay, our coding is okay, and that they can put this in place.
Commissioner Bennett?
Commissioner Ray?
The last sentence too, the public communication and administrator set to remove the word bulletin.
Oh. Just the administrative order.
That makes sense.
So essentially what this does is say that we will very soon, I put in tomorrow at noon,
That's right.
issue a communication advising what the executive order would say in the event that the executive order needs to be issued because the bill is signed. So it's giving advance notice without overstepping.
That's right. I think that works for the administrative order.
Yeah, and I do, yeah, okay, I think that this is great work. I really appreciate the work
Thank
of
you.
all the staff that has gone to put this together, but you know, thank the 2 commissioners for crafting this legal language, which is really important.
So moved, if she read it into the record.
Okay, I let Commissioner Bennett on second that motion.
Second,
Having been moved and seconded, I will call the roll. Commissioner Bennett on,
aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. Unanimously passes, and maybe it saves you a little bit of time on Sunday, Mr. Executive Director. So,
May we have a 5-minute break?
yes, we may.
Thank you.
You're moving, Commissioner Stebbins is seconding, and we will be back at 2:50.
I appreciate that. Thank you.
I'm getting it around.
What's that?
Thank you. All right, so staying on, number 10. Also, you know, we've had this conversation in a couple of different meetings. And obviously, you know, some of this preceded, what, you know, has been a sped up process of passing the new law. Talking about, and we've done some research and have heard back some of the issues that have been raised about our the highest number of notices of deficiency. And one of them has to do with advertising. And this is also, just as we've just done this with purchasing limits, you know, one of the things that I would suggest is similar language. And I don't know, you know, I don't know how people feel about this, but I wanted to raise this. I recognize that there's language in the potentially new law that could take away some of the prohibitions of loyalty programs, things like that, discounts. So I just wanted to raise this with my fellow commissioners to determine, just as we've just done, to in advance allow the increases in the purchasing limit regulations, to see how people feel about directing our staff to, consistent with the language of the new law, but you know, that we would not be enforcing the current prohibitions on advertising, but in particular the discount and loyalty programs. And I just want to see what people are thinking about that. I think it might make some sense, but just asking, you know, folks for their feedback, whether or not it does make sense. Again, I just keep looking at the stories we've heard, you know, about Pure Oasis, you know, these businesses just going out of business. And this has been, I think, in terms of the red tape reduction, this was one of the number one requests that we've had from licensees to allow this to occur. It seems to be occurring in the breach on many occasions, and I think that this is a headache for our licensing and enforcement team as well. So anyway, Commissioner Roy?
I think it would be helpful to have our co-CIEs come up and say what they need from us and enable them to be able to do this and execute on this. So whatever tools they need, I think it's important we hear from them.
Yes. And maybe Olivia as well.
Chair, we're under 10 for advertising at
The
this.
non-enforcement of conducting, we had put both in. Again, this had been something that we were anticipating previously. And again, with the emergency preamble, this kind of happened faster, or is happening faster than we'd originally anticipated.
Yeah, and I guess, Madam Chair, if I may.
Right.
So my question is around 500-105-20. I'll read it. Advertising through marketing of free promotional items, including but not limited to gifts, giveaways, discounts, points-based reward systems, customer loyalty programs, coupons, and free and donated marijuana, except as otherwise permitted by 935 CMR 500-105-4A9, and except for the provision of brand name takeaway bags by MEs for the benefit of customers after a retail purchase is completed. So in the House bill, it speaks to, I believe, discounts, loyalty programs, but it doesn't speak to gifts, giveaways. It speaks to some of the language in 500-105-20, but not all of the language in 500-105-20. So to selectively not enforce certain elements of it, what would you need from us based on the statute and based on our current regulation? How do we reconcile that?
I think I'm gonna start it up anyway. Catherine, I'm sorry, I'm still used to having you back at the table, so my apologies. Thank you.
Thank you, Madam Chair. And Commissioner Royce is speaking with specific regard to the language that is in House Bill 5350. So that language does allow the commission to create or revise regulations to allow for in-store advertising of in-store discounts, as well as opt-in email marketing. I will note, just as a general practice, we have allowed and permitted that.
Allowed that,
The
yes.
interpretation of the agency thus far has been that these are the following advertising activities that are prohibited, and our regulations define advertising as a sponsored, non-personal message. So as we've interpreted this, if somebody goes into the store, as if a consumer goes into the store, they are opting in, or they are actively seeking out that information. So bud tenders have been able to communicate if the licensee has a promo, a discount, something along those lines. I will note, however, that we explicitly do not allow free or donated marijuana. So if there were any sort of discount program or something like that, it could not be reduced to free, because that would be in violation of the statutory language and the prohibition there. So that has been consistent with our interpretation. With respect to opt-in email marketing, this is a longer standing interpretation of the department as well, is that in the agency, I should say, the prior commissioners in their conversations related to advertising, though they seem to be more focused on prohibiting unsolicited advertisements. So if there was some sort of
mass marketing,
unsolicited advertisements, we're thinking mailers that go out to folks, and they, I believe, specifically in the public meeting, if I'm remembering correctly, referred to telemarketing calls and pop-up ads on the internet. So, and as well as social media marketing campaigns. So the original intent, from my understanding, was to prohibit that. So in essence, if a consumer now has, or over the past several years, if they specifically requested to be included on an email list, then we have generally permitted that, or we have not taken an action against that specifically. So since you're talking about advertising with respect to the rest of these items, I do just want to note that the statute does explicitly prohibit some of these items. The commission also went further than what is specifically articulated in the statute as well. So if there was to be any kind of change with respect to that, that's something that the board could consider, but I definitely want to defer to the rest of my colleagues up here as well.
And thank you, Enforcement Counsel. What we've heard is that your team spends a lot of time around advertising. Heard that, right? And so that was on your list of things to address. And what I hear from licensees is because of, and I've gone on podcasts and I've explained just the way you explain it, I explained it, but the enforcement hasn't been completely uniform because there's a lot of gray area and it's very nuanced and there's the ambiguity. And so I heard from a licensee last week that said, I got an NOD and the guy down the road doing the same thing didn't. So what we're trying to say is this language, some of it, like obviously we were not going to allow free and donated. So, but part of this language, we could say no longer enforce, which with the law, the statute will supersede this upon effect, correct? So do we need to do anything to help you so it's not ambiguous anymore?
Madam Chair, and I definitely ask for my co-CIE Armeninos and Director of Investigations Catherine Minkowski to kind of weigh in on this as well. But my understanding of the bigger hangup with respect to this regulation is advertising on licensee websites is what takes up a lot of time here. So I know that the language in the bill is a may. So it is not kind of declarative, or directive rather. But as we're looking into this too, I think one thing for us to generally consider is whether in-store advertising or whether the website effectively functions as an extension of the store. So that is something just for consideration here, because I know website advertising is really where a lot of the work goes in.
Someone going to the website almost be like opting in.
That's what I was gonna ask. I'm 21, you're opting in.
You opt in, yeah, go ahead.
Thank you, Madam Chair. Yes, just to build on our co-CIE good and statements. Yes, so we do require that our websites have an age gate on them. I think the reality, though, the potential challenge with solely relying upon that is anyone with an internet connection can click that button that I am over 21, but it does not mean, in fact, you are 21. As co-CIE Gooden also said, he's absolutely correct. During previous public meetings, I had raised some of those most commonly cited NODs. Website advertising is by far one of the top. And I would certainly allow Director Binkowski to kind of elaborate on that. But as we have said before, her team does spend a lot of time.
But is this not going to be authorized under the new law? Mr. Roy?
Or did you want to?
Sorry.
Okay. So someone hits the button, they're 18, they say they're 21, and they look at the sales. But they can't get into the store if they're 18. So they can look and they can order, but they can't because they have to show ID. So that's the ultimate gate, is they cannot get the products. They can, and so is it an extension of the sales floor? Are folks opting in? They are opting in. Now, if they're 18 and they're opting in, I don't know ultimately how they get the product, discounted product, because they're not 21. So I think we need to address it, because I think it's a gray area and you guys spend a lot of time on it and we want to help you so you don't have to. And so if the board's intent is let them advertise on the website, how much time, effort, and energy would this save your team?
Forget everyone's titles.
Oh, Catherine's perfectly fine. Madam Chair. This would alleviate a huge burden off my team, and I think allow my team to focus on more pertinent investment public and compliance matters. Like you mentioned, we do get, frankly, daily probably emails from licensees complaining they received an NOD and perceived to be disparate treatment. A lot of the time it's just because we haven't received a complaint from that other.
That's right.
And it's really serving as police and sometimes looking at the nuances of words such as special, promo. Will they put special price? Is that the same thing? So if the new statutory language, if the interpretation was that the website was an extension of the store and that included in that was equal to opting in, that would be a huge burden off my team.
If I may.
Commissioner Roy?
So would you agree that if we allow that, and yes, I mean, youth access a lot of stuff online, and they say, yes, they're 18, and would you agree they have no easier path to get the product because we allow a discount online because they can't get through without the proper ID to purchase the products. So it's not going to avail products to minors physically, right?
The same ID protections would still be expected.
That's right.
to work.
So we're not putting youth at risk to physically access the product is what I'm trying to get. They can look at a discount, right? 3 pre-rolls for whatever. But at the end of the day, can they get their hands on the pre-rolls by ordering it and going in directly? And by us saying they could advertise that online, I don't think we're putting youth at risk. And unless somebody can.
But this is also, someone raised the Joe Camel, you know what I mean? But this is not like broad advertising. This is, you kind of have to go there, you have to walk in, you have to, you know what I mean? I mean, it's a little bit different than widely broadcasting a message or making something necessarily look enticing to really young kids. So I do think that there is a special.
I just have one other.
Sure.
Would anybody on your team see any problems or have any objections to this board allowing folks to advertise their discounts on? Like, is there anything we're not thinking of that you see as problematic? Or is it they're opting in and it's going to allow your team to focus on things, other compliance, where they're getting bogged down substantially? And I'm not saying that's the only reason to do it, but it is a factor. And is there any public health issue that you can think of that would be problematic for us to say, because I can't see one right now unless there's one I'm not thinking of.
No, I don't have any public health concerns, and I can't think of any my team has raised. I know in terms of reducing the stigma, it's also been brought up as other industries are allowed to advertise their product on their websites.
Right.
Kind of further prohibiting marijuana in a way that other substances aren't, further stigmatizes it.
Mhm.
Billboards are a different part of the regulations that have its own restrictions.
That's right.
But there would be maybe exposure for an underage person to see what's on the website, but frankly, there's no.
They're seeing the products. It's like not the discount that's
There's
harmful.
nothing that.
The discount itself is not harmful. Yeah.
But ultimately you have to go look for it. You know what I mean, a billboard or TV advertising, it is thrown at a kid. This is, someone has to go find it, and Attorney Gooden has been raising his hand.
Thank you, Madam Chair. So we just, not specifically with respect to public health and safety or youth access, but one thing for the board to consider for future consideration as well is kind of additional guidance or clarification in terms of what discounts might be allowed or what discounts the board might disagree with. So I know we mentioned like 3 free rolls for X amount of dollars, but to kind of build off of Catherine's point earlier as well, identifying specials or promos or anything along those lines. So really, I think part of the difficulty here as well is that a discount can take the form or can take many different forms. So at times what we've seen is a licensee had a product on for a price and then they will strike through that price and add a new price. They've read or something along
Attorney
those
General's
lines.
office said to us that those were the complaints.
Yeah, and so we've definitely received complaints on that. This is a bit of a game of whack-a-mole though, where as soon as an NOD is issued for one thing, the licensee kind of changes up what that looks like and they will add something else on there. So we have had areas or instances where something is identified as a sale or a discount. When we identify that through an NOD, they will then say, okay, well, we've put a strike through on that. That is no longer advertised as a sale or discount. Then when we try to take an action based on that, then a licensee tries to put that onto a second page on their website with an additional age verification to try to identify it that, or try to kind of couch it into another drop in because they're couching it as opting in. Generally speaking, as has been discussed here, anybody can access a public website. So that is part of the concern that this is generally advertising. It is non-personal in the sense that it is broadcast out widely. However, we do understand the point that is being made here that a website does not just pop up on your computer. You have to actively navigate to that website. So just as the board is considering this as well, kind of considering what does a discount look like, or what would be an allowable discount versus a disallowed discount or promo? Is there any kind of limit where the board would say this is no longer acceptable?
I thought I heard you say earlier that you were not, that the loyalty programs are okay. Just clarify for me, because I'm not sure I'm understanding what you're doing now and what you're at. Could you just deeper on that?
Yeah, I guess, so in essence, is there kind of a maximum discount allowed? So can a licensee discount something to 50%? And now the legislation allows the board to consider advertising of discounts within a marijuana establishment or through an opt-in email list and branding, advertising, marketing, and branding of sales, discounts, and customer loyalty programs within an establishment or through an opt-in email list. So really kind of thinking about or adding additional clarification in terms of what is there a maximum discount that the board would want to allow? Perhaps there isn't, but just out of curiosity in terms of allowing too much of a discount, you could argue could potentially lead to a diversion risk.
Well,
and also,
now that you're saying this, I'm now starting to argue against myself. Especially, in terms of the conversations that I've had with licensees who told me, again, because of the inversion issue, and that I'm hearing some licensees say that they cannot compete on price with people who are cheating. So I'm now thinking a little bit about, you're making me think about that, because I worry, I don't want to provide too much incentive if there are those folks out there that we're still getting our arms around inversion and what's happening, and how are people inflating THC? How are people, there's wild diversity in terms of pricing. So I'm now arguing against myself.
Madam.
Yes, go ahead.
Just, thank you, Madam Chair. Just really quickly too, I want to be clear that I'm not suggesting that there's anything nefarious going on here. I'm just saying, like, to the point or the discussion as well, just some clarity in terms of what is allowed, what is not allowed. I think that would be helpful both internally for our team to assess and determine compliance, but also as a general expectation for the industry in terms of this is how much you are allowed to advertise as a discount or a sale within your store, or through an opt-in email campaign as well. That could just add some additional clarity so that we know where the bright line is in essence.
I'm not
And
saying that you're
avoid the
saying that there's anything inappropriate with offering these discounts, but you understand what's happening out there, right? And this is why you raising that raises a question for me, about.
I think I can help.
Yeah, Commissioner, go ahead. You know what I'm saying? I'm trying to sort of thread the needle here, making sure that we can reduce the number of entities. I mean, it feels like the website advertising is one thing, but the discount thing is.
So-
trying to figure that out.
The intent was regulate us like alcohol.
Yeah.
So what applies to alcohol with that were discounts and key alcohol restrictions in Massachusetts, no happy hours, no discounted drinks, half price cocktails, 2-for-1 deals. Consistent pricing. Prices cannot be lowered for a few hours, even for a day. They must remain the same all week. Below cost sales, retailers are banned from using loss leaders selling below cost. Limited promotions, free, right? Free is generally forbidden, except for authorized like tastings. And permitted exceptions, establishments can offer free food, blah, 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 blah. So how do we would need to like translate that into cannabis. So with social consumption, I think the happy hour conversation is actually relevant because I could see that popping up in a social consumption establishment. So for retail pricing restrictions, to Enforcement Council's point, prohibition on happy hour discounts. Number 2, consistent weekly pricing. Number 3, below cost sales ban. And number 4, limited promotions, free cannabis samples or giveaways are forbidden except authorized by the Commission for Compliance Testing or Events. And no cannabis items, food may be bundled if compliant with social consumption rules. So I think we can glean from alcohol if we're going to regulate cannabis like alcohol and apply, because to co-CIE's point, you need some direction on what a discount can look like or shouldn't look like. So I think those are some safeguards.
But also thinking that there is a difference with alcohol and THC. It's literally, this is a little more like gasoline, like, the ethanol, you know what I mean? The higher quality and, people seeking price.
So I think that's why the below cost.
No, but I think that the below cost, that is.
Like the fire sale thing.
Yeah, but how do we, trying to think of how we enforce it? Or I don't know I wonder how they enforce with the ABCC. How do they enforce below cost? I don't know if anybody knows that. But this is one of the concerns that I do have is protecting some of the little guys, right? And we have seen in the state of Ohio that the Attorney General, brought a lawsuit. There's price fixing, like raising the prices. We have the opposite problem here in Massachusetts. And again, the anecdotal information that I'm hearing is that there may be selling product below cost to create those competitive pressures against smaller businesses that won't be able to compete. So I'm probably just throwing that point out there, but, and we may not be able to get this done today. It was my hope, but I do think that, but I would ask to see how the ABCC does that. How do they enforce that? How do they look at what's below cost? Because again, and I apologize for keeping on, but it's just getting so much feedback from licensees who are, I mean, I've told you, I've been near tears, talking to people who are in tears about my house, my family, and I just want to make sure that we're protecting the honest players, but also this is also a little bit of red tape. How do we remove this red tape to allow them to be more profitable? So Commissioner Roy, do you think?
Question. So when the House Bill 5350 becomes law, how do you, now what happens with your team? Because that's, the statute will supersede the current reg. So how are you going to approach it?
Second. Yeah.
Hey,
I'm sleeping.
So Madam Chair, since the statute really is in line with what our current practice is, I think for in-store advertising as well as opt-in email campaigns, that is not going to create much of a change. As we were identifying though, I think we will definitely take a look to see whether that also could apply to websites. However, not committing to anything on that right now. I think we would need additional time to look into what impacts the new law or the change of the law would have towards our compliance processes. Would also definitely invite any of my colleagues to weigh in on that as well. But I think for this, it makes sense as we are moving forward with this. It would have kind of not a substantive impact in our process, but we would be able to actually point to the statute. I do want to just note with alcohol sales as well. And again, just want to note that this is something that I would request additional time to look into to just make sure. But my understanding is that pursuant to ABCC regulations, alcoholic beverages are not allowed to be sold at a price less than the invoiced cost. So I believe that would be consistent with the wholesale price. So that's my understanding of the standard on the Alcoholic Beverage Control Commission side of things. And I imagine that they would monitor compliance by identifying whether there are sales. Now with marijuana, we have seed to sale tracking, obviously. So we would have to kind of figure out what the process looks like for monitoring and auditing. But when we're talking about kind of guidance in terms of what kind of discount would be allowed, with no guidance right now, licensees can discount something 99% potentially, which may or may not be the discretion of the board. However, when we're looking at, if we're trying to draw those comparisons, the Alcoholic Beverage Control Commission, at least looking at some of their regulations, that is kind of tied to the wholesale price as well. So the invoice cost that the business actually had. So there's something for consideration as well.
Sure, right.
So if I'm hearing correctly, there's no issue with on the enforcement side of the ledger, if the future board or this board or the future board's intent is to allow discounts on their websites. The issue is putting the safeguards and parameters in place of what constitutes a discount. Is that what I'm hearing?
Thank you, Madam Chair. Yes, Commissioner Roy, that is my understanding. And just to kind of, hit another point that was brought earlier, as Director Bienkowski said, again, if we're talking about strictly advertising on NODs, again, our staff issuing those NODs, as he said before, if we were moved by the board to stop that, again, we are not increasing the likelihood that anyone under the age of 21 is physically going to be able to obtain that. So I just wanted to hammer that home because that was a very important point.
So I think these are really good. So one of the things I might suggest is maybe we deal with, we're not going to be able to come to a conclusion about discounts, right? Today. Oh, I'm sorry. Did you bring it up?
I did. I just wanted to point out that the language that is in the bill is permissive, not mandatory. It just says that the commission may authorize these certain forms of advertising. And so I don't see this as something that requires immediate action because of a conflict. There's no conflict. We could decide to do nothing and to never allow this advertising, and it would never conflict with the bill. So it's not even something we have to take up. I would be inclined to take it up or for the next board to take it up. Yeah. But we are not leaving retailers or our enforcement team in a position where there's a conflict that now they have to deal with. They just have all the usual challenges that they've always had with these issues.
All right, and Commissioner Stebbins.
Yeah, I would like to give our licensees a little more clarity, as you pointed out, and Enforcement Counsel, you pointed out with respect to what we define as discounts. I'm still not necessarily in agreement or want clarity on whether a website is part of a marijuana establishment or an extension of a marijuana establishment. So I hope as things move along, you have the opportunity. I know you've expressed an interest in clarifying a lot so that maybe our licensees don't get as many NODs if we can clarify our regs, but for me, those would be answers kind of going forward that I hope you could address.
So, right, so are you looking, so are you saying you want, so are we then stating, I mean, do we think that we, all right, Commissioner Roy, because I would be comfortable
Yeah,
with the website.
I would too. And if I may, Madam Chair, I think to be to have parity with the alcohol industry, just doing a cursory search, Massachusetts liquor stores can advertise their prices and general promotions on their websites. But it says they're prohibited from advertising, offering short-term discounts, coupons, or loyalty programs. So I think we need to maybe look to see what the alcohol industry is doing and how that translates, and also knowing that social consumption is on the horizon sooner rather than later, and how that translates to that, especially with the happy hours. So I think, I don't think we can solve this. I am inclined to say, yes, let them discount on their website and, but I don't think we can solve it today.
But I think but they can no, they can't discount on their website, but they can discount for people who
In the
have
store.
in the store. But, so just clarify for me again, is there anything short of us today having to review what the ABCC does that we could take a burden off of you and get rid of some of these NODs? Or do you think that we still need to, I mean, try to figure out what we can do to, just smiling. Director Enos?
Thank you, Madam Chair. May I invite any of my colleagues to kind of chime in here, kind of just throwing something for the board's consideration. I see these as all interrelated matters, and I see how, obviously the consumer side and then with the employee side, we have to think about that as well. I do think there is room, though, if the board wanted to, in the immediacy, kind of move that we as a staff, for the time being, do not issue these kind of violations to allow us time to look into it, and happy to come back to the board. And again, that is just, again, with the idea of just knowing how much time Catherine's staff, I think that's what we're trying to get to.
Today, but that's, I think, exactly.
I think we could split this up though, Madam Chair. I think we could do this in a couple phases, but I think if the board wanted to consider for today's purposes, a potential, motion to direct staff for the time being to stop issuing NODs for violations observed on licensees' websites regarding prohibited discount product.
That, I just, how
Are you comfortable?
I'd like to hear from Enforcement Counsel in terms of that might do to your level of work.
Good.
Thank you, Madam Chair. I mean, I think Chief Enos's suggestion could make sense here. I think as a general matter, I think it does make sense to kind of pause a kind of further direction if we're talking specifically with respect to what is in the bill. That would, I think, make good sense considering that seems to be the direction that the legislature was leaning in. That seems to be the direction generally that the board is leaning in as well. If you wanted to, I just want to know websites isn't included in that bill language, but to the points that we're raising here, websites do see that is the area or the sticking point generally. But I do think that as a broader point, time to look into the advertising, time to look into or perform an analysis on whether websites can be construed as an extension of the store there, whether that makes sense. I think some additional time to look into those particular areas would also make sense.
So how might we frame something like this?
Enter.
Commissioner Ray?
Give me like 4 minutes.
Okay.
I'm Commissioner Bennett on it.
No, I mean, I feel like it's not such a simple thing for us to sit here and do today and decide what we are going to not enforce or not issue NODs. I'm happy to work on it. But I would be inclined to make sure that we're being thoughtful and not rushed in doing that.
Commissioner Ray? I'm inclined, so.
No, I am inclined to. But I also hear the other side of the argument. So how much time through the chair
Please.
would you need to suss out what the alcohol industry is doing for safeguards on the websites and what they're allowing and what they're prohibiting and how that would translate into the cannabis industry? Realistically, how much time would you need? And you know, your cup runneth over in a million ways, all of you, and I know that. But the industry is struggling. We know that. We've seen closures. We've just read about it in the Boston Globe. And I think this would be a welcomed change, course correct, if you will, for licensees. And I want to say there's a sense of urgency, but for them, there is a sense of urgency. And so I'm inclined to allow it, but Commissioner Bennett makes a great point, right? We're trying to solve all the problems today. It feels like, it kind of feels that way, right?
But these are new. We've been talking about this for many months, right?
Yeah.
We've been talking about, I mean, we literally asked the team to put together the NODs specifically, you know, to inform our, you know, and this is my concern, is that the emergency preamble has like shaken up everything that we have had in process trying to be responsive to the industry. And what I worry about is not doing something when I see 30 licensees in receivership and another 30 queued up in. Pure Oasis wasn't even in receivership. So that's my sense of urgency. So Commissioner Rice?
And I know the executive. In the medical treatment centers, can they discount on their websites?
Director McCuskey?
The 501 regulations do not have the same
It's not permitted.
prohibitions. No,
So they can, that's what you're saying.
medical
So
patients,
it's happening now. So there are discounts on websites now and under MTCs.
yes.
Happening now.
Okay. Executive Director?
Thank you, Madam Chair. Can I just clarify? I think the point that was made was kind of breaking up into chunks. Is the specific question right now in terms of when it could be accomplished related to essentially treating the website like a continuation of the business? Is that kind of the intent to move as quickly as possible on, or was it? Okay. And so I think for that, the question, I would say if we're ready to answer that right now, which I don't know, would be whether or not that is as simple as that determination right now by vote, because I think that's the question.
But I would just suggest it's a non-enforcement, and in a week, if there's a completely new board, they can say, get back to work. Right? Do it.
Let me ask you this.
Yeah.
May we just say, allow.
Sorry, that was great.
501.
Poor phrasing,
Like if we
sorry.
had motion language that said, the allowance is under 501 around that. Could apply to adult use because they are allowed to discount on there. Could we lift language out of 501? Into,
And if I could just rephrase, it's put back extra hats, okay? If I don't want to be so flip, I apologize, so.
and I'll draft the language.
Yeah, but so we do allow that for medical.
I'm saying it's happening now, right? Sky hasn't fallen.
Yes, the 105 4B20, which is the prohibition on certain promotional activities by adult use, is not a regulation that 501 has. So I defer to the lawyers in the room, but whether 20 would need to be struck
In order to do that, I'm not sure.
Commissioner Bennett, oh, did you?
I was just gonna point out that I'm not sure it's so simple as borrowing from 501, because 501 doesn't have the prohibition. It's not that there's
Right.
language there, we can
Silent.
borrow. It's
Right.
just silent.
Silent.
Whereas the
It's-
prohibition is in.
But I think that right now, it's the direction that we want to do with people wearing so many hats to allow them the ability to focus on what I consider higher priority public health and safety issues. And we know, we're hopefully gonna start doing, more stuff around Seawood Chopper, that there's gonna be a lot on your plate, that there's a lot of pressure on you guys. So that would be my only sense, is that it really comes down to just a consensus and a direction from the commissioners. And then if it's not, and with further review, you're gonna go, there might be some way to say, oh, this is ridiculous, don't do that. It's not like alcohol. I mean, that would be my only, so I just wanna, I would like to almost call a question right now, unless anybody has any further, questions. And I don't know if you would like to make the motion that I can't do it, has suggested that it's direction to the staff to not enforce what is currently there, because we are in sort of an emergency situation. I mean, one of the conversations that I've had recently is we do have some emergency public health issues out there, and we have an arduous process, and you have an arduous process, whatever happens to us, you have an arduous process ahead to move forward on testing protocols, to move forward on, and so that's on you, okay? It might not be on us, but it's gonna be on you. And so, I had thought about, should there be some emergency regulations and do a new process? That's obviously, we don't even have time to do that. So that might be just, if you want to take 5 minutes, and again, you may not think that this is timely, and I don't know if, what your thoughts are, Commissioner. I don't want Commissioner Roy to spend 5 minutes drafting something,
That goes down.
our best JD without a JD. But, are you inclined to go along with picking a couple of hats off so that they can focus on higher priority health and safety issues? Or are you not comfortable?
As I look at this, is the pending statute language, right? It does say for me, and again, all of us, me, whoever may not be here for the next consideration of this, but it's May. I still have a concern about within a marijuana establishment. I don't necessarily agree with Director Enos about, a general context of us deciding what should be enforced and what shouldn't be enforced. Right? These regulations are on our books. I know we've had many conversations about that, but for this board to necessarily take a vote and say, we're asking you not to enforce this, I have a problem.
Okay, then, all right,
If I may.
Commissioner Roy?
And thank you, I appreciate that. And there are two coins to the other side of the coin. Because it's happening now, it's not new terrain, it's happening now with medical treatment centers. So there is an existing practice. And so I think they're bogged down in these NODs. And I don't think I've spent my career on youth prevention, and I'd be the first one to vote no if I thought this was going to subject youth to these, products underage. And I don't see how it does. And so I just feel this is something we could positively do, not only for our staff, but for our licensees I think the concern is youth exposure or youth, access. And I don't see how it increases youth access. And I'd be the first one to vote no vociferously if I thought it did. So then if they're not 3 votes, then it is for the next board to decide, although I would be in favor today to support what Director Enos said.
But I don't want you to waste.
No,
I don't want
to get tired.
So I don't want you to have to do the legal work. So anyway, all right. Thank you. This is a great conversation. I learned a lot. This is actually, Commissioner Stevens's, issue, the non-enforcement of property control for, provisional licensees. So I don't know if if your posture is consistent, but I put this on because I thought this was something that you were concerned about.
No, and I appreciate that, Chair. You know, we've talked about this issue before, or I have, I think, Chair, you've echoed this.
Support it 100%.
You know, I would love to see us move to a system where property HCA requirements, which are under the provisional license, get moved to a final license phase. And I know that probably comes with a lot of homework to figure that out. But we've all been exposed to the stories of, I've been in the provisional phase by trying to raise capital to get to the next phase. And I'm holding property that I'm not using. Chances are a lot of these licensees have kind of paid a green tax on what that rent probably was. And as we look at, you know, I looked at some cultivators who have been in that provisional phase for years. I would love to see us change it. It's shall in the regulations, so I don't think it is as simple as the solution we would hope for to just say, scrap that part of it. But I hope that, you know, we can send a message loud and clear that this is a big anchor around the neck.
Have you had a chance, one of the things that we put this, have you had a chance to sort of look at the impact? I know that you were, you know, thinking about that. So again, I put this on because I thought this was something you wanted us to do. So are you not in?
I was exploring not necessarily the non-enforcement of it. I was looking at, can we make a change? And knowing that the language in the reg says shall, I don't, from my perspective, and again, I'm not a JD, from my perspective, I don't think it's something that we can overlook necessarily, but hopefully, you know, sending a strong message for, and I think about this with respect to social consumption, where we have a lot of equity players who are thinking about what property they might take.
Right.
Love to be able to send the signal to them that hopefully the next iteration of commissioners will move this to a final license phase. And
Again, this is one of the reasons that I support it, is because I think it has also it's a disproportionate impact on social equity applicants. So anyway, Commissioner Roy.
Are we truly boxed in though? I mean, it's in regards to the application of intent, number 7. If the board gave a directive to
you're
not,
sorry.
yeah, like in the reg, 500-101, number 7, documentation of property interest in the proposed address. The proposed marijuana establishment shall be identified in the documentation as the entity that has the property interest. Interest may be demonstrated by one of the following: A, B, C, D. We didn't enforce tier relegation is on the books, and we're probably glad we didn't, because, you know, we realized maybe it's not an effective tool. So my point is, if there was a directive from the board saying under 500-101-7, A through D, to no longer require that on the application of intent, and then later, and when we go back into regulation, we can fix the shall to a may. Can we do that? Do we have the authority to say in the application of intent, you do not have to enforce number 7?
Attorney Good.
Thank you, Madam Chair. And Commissioner Roy, just not specifically identifying on the shall or the may, although I do want to note to your point there that with respect to tier relegation, that was permissive language, that was a may. Shall is the directive language, which that is why we have consistently required that as part of the application. I would definitely ask Director Koval also as the Director of Licensing to speak to some of that, but I do want to just identify a few other related regulations that also are kind of contingent on that specific property area. And so want to thank Director Koval and your team, in particular, Licensing Manager Defoe, who I believe compiled some of this. I'm sure Licensing Manager Moriarty and the rest of the team also contributed too, so we don't want to leave anyone out necessarily there. So in addition to that documentation identifying the property interest that is required in the application, there's also a requirement that the applicant has conducted a community outreach meeting. That, generally speaking, and speaking to my experience, working within the city of Boston. But in order to conduct a community outreach meeting, you generally need to provide notice to abutters within a certain area. That requires a specific property location to identify those abutters, as well as.
It's redundant because you have to do that already with zoning and with property.
And you have to do, it very well might be, I'm more.
So no, I'm just
trying
saying,
to
I mean,
identify these.
and in Greenfield, you not only have to do the host community agreement and you have to notify your abutters, but when you're going to be applying for any sort of local, you know what I mean, use for business, you have to go to.
Yes, and Madam Chair, in addition to kind of the community outreach meeting there and identifying the abutters, our team also does a buffer zone analysis as well, and that requires a specific location. So if a licensee is moving forward with a provisional license, they identify that particular area, we identify whether it complies with that buffer zone too. So not to say that the suggestions here to shift that location requirement to a final license does not make sense. I think generally speaking, like from what we've thought about so far, that very well could make sense. However, just wanted to note that there are a number of other interrelated regulatory requirements that we utilize that property location to ensure compliance with otherwise. And just also noting the documentation of evidence or permission to use the premises. That's really just to identify that a licensee isn't using a placeholder. If a licensee said, I'm going to be located at Disneyland, they are obviously not allowed to use that location. So we want to make sure that they actually have the ability to utilize the location that they're identifying in their application so that we can then complete our assessment on the community outreach meeting as well as the buffer zone in accordance with that location.
And thank you, Chair. Thank you, EC. I started off talking about the property, but yes, I fully acknowledge there are other components tied to the property that are part of that initial provisional application. We've had some conversations about those local meetings and how they could be better carried out, but I wasn't just suggesting that the property location, 7, 8, 9, 10, I think under that 101, I would prefer to see shifted over.
Again, I think it's not so much the location, it's the ownership interest. And it's having to pay a lease. You know, and again, I often, which is boring, I know, but use my own experiences. I was very lucky that I partnered with a farmer, and that was his contribution to the venture, which was he owned the land. So we didn't have to, while we were going through, you know, months and months and months of application process and everything, we didn't have to pay rent because that was part of his contribution. And you know, we've all gotten emails from social equity applicants who are concerned, and you know, it also is tied to, although apparently it may not be as tied right now, but tied to the ability to access funds from the Cannabis Trust Fund. And so we've had concrete evidence from at least one and possibly two social equity applicants who are trying to get, and we saw that with in another case where we hadn't been able to approve a provisional license, or we had someone who wasn't in compliance with their provisional license and they were trying to get money from the fund, which is the biggest barrier for social equity. And so this is what I see is it's a cascading effect. It's not only it's not only all of the things you're saying in terms of identifying this for the community, but it's really what is that ownership interest? Lease ownership, there could be an agreement without it, but I see this as one of the most significant barriers for social equity applicants to literally being able to stand up to the plate, but we can't do it today. We can't do it today. So, but thank you very much. Commissioner Benedict?
I want to add, in addition to the things that EC Gooden noted, when social consumption comes online in particular, there will be additional things that are linked to the specific location, the transportation plan, the security plan, which has to be reviewed and discussed with local police. So those things are going to be very location dependent. And so I think in the future, the thing that is really worth considering is not should you be able to proceed without having a location determined. I think all of these things you have to have a location, but maybe additional methods short of paying rent. And I know there are 4 different ways, but that's something that can be considered down the road, as well as can you proceed with a specific address that you don't actually own or have the right to use But then if it turns out you don't end up getting that address and have to go to a different address, you have to restart the process. I think there are a lot of considerations here, and I would like to make it easier and lower cost, but so much is tied to the location.
I agree with you, but I do think that with the social consumption, the property is going to be so tied to the function. It's so tied to the local, you know what I mean? It's, again, having been through the process, you can go and apply, there were several farms that we're looking at. So we had to wait until we identified the farm. We were talking to different farmers, but we had put together the team. We had put together all of our, our policies and everything. But getting that piece of property for cultivation, for retail, I think that I agree with you, but on the other hand, I think that it's going to be sort of different because A, it's going to be very, very limited. B, there's going to be a lot more local. And, as I was pointing out, E.C. Gooden worked in the city of Boston. A lot of this already people are already protected by the local zoning law. So, but anyway, it looks like we may not have the votes to do this. So we had a good conversation and, I think that we are making some progress here. So thank you very much. I'm just trying to think. Let us go to the publication of the receivership reporting form. And I think the legal team is going to be presenting that about publish it, or did they say that they couldn't get that done? I can't remember. Do we not have that done?
Madam Chair, we do not have that ready to go as of today, but I do think in discussions with Commissioner Roy, we're certainly approaching that point. I know the EC has put thought into that and that it still needs some final reviews so that everybody gets what they need out of it. But I believe Commissioner Roy did have a thought on a next step for that.
Sure.
Thank you, Madam Chair. Thank you, Mr. Executive Director. If you could give us an update. So I did an initial iteration of the form and I shared it with enforcement, and so we're in good shape, right? The form is not far off, right, on the horizon?
Madam Chair.
Please, thank you.
Thank you. Yes, and obviously EC can go through the work that was done as well, and so some of the final reviews. But ultimately, I think we had discussed when you had provided that it was going to be culled down. We're going to focus on what we can require somebody to provide us, which is one of the checks that we went through. What is the information that obviously the most helpful for all parties involved, whether it be the legal side of the house or licensing, et cetera, commissioners for information that they'd be looking for. And so to make sure that everything that we're asking for is either clarified that they must provide it or we're asking for it because it's good for information, and that the report is as succinct as possible, but also as helpful as possible. And then we would do that continuous for posterity and then have that data moving forward. So just really kind of in final stages.
Okay, thank you, if I may. And so I crafted some motion language. I shared it with the executive director. And any concerns with the motion language? Do you think it's something we can?
I think that form by the end of the month is fine.
So no objections to anything in the motion language?
No, I don't see anything.
Okay, and yes, if I may read it.
You want to put that, is it in the chat?
Oh,
sorry.
did I not put it? Did I?
You may have, I just haven't.
Oh, I'm sorry. Let me do it right now. So since the first original motion language for bandwidth issues was not adhered to, I think it's critical to keep this on track. And the form seems to be in fairly good shape. It's almost ready. So if I may, Madam Chair.
Yes, thank you.
Move that the Cannabis Control Commission direct commission staff to develop, finalize, and publish a standard receivership reporting form and corresponding monitoring process for cannabis business receiverships under the commission's jurisdiction, and to present the completed form and process proposal to the commission no later than April 30th, 2026, or within 14 days of adoption of this motion, whichever occurs first. So the new iteration of the board will have the final say on what the form will look like. We just want to keep the forward progress going.
Thank you. All right, I will second.
So moved.
I will second that motion. Commissioner Roy, any questions or comments? Commissioner Benedetto?
No.
Commissioner Stebbins? Having been moved and seconded, I'll call the roll. Commissioner Benedetto?
Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Chair votes aye. It is unanimously passed. Thank you very much. And this is going to be this was, I just want to raise this. This is, we not only have the form, but this is going to be with the conversation about publishing this on the website. There was some question, unless that's, is that, that is, you have published, okay, published, okay, great. But we had published, but we had some questions about how many we were going to publish at one time.
No, it was, I think we wanted to hit a number of receivers, but
Yeah.
I think that we decided,
No, but this is the point, is it's not our job to determine,
well, plus the new law,
right,
the caps are gonna go up on retail, so that is also a different,
right.
dynamic.
But I think it's, from our perspective, it's whether, the caps go up or not, I don't think it's our job to police that. It's really got to be the receivers. And this is also when you finalize, when that is finalized, one of the things I would suggest is that the receivers have an affirmative burden, duty, whatever, to make sure that they are clarifying, again, there's going to be more room, but whether or not they're abiding by the cap rule. So that we don't have to follow it. The court doesn't have to follow it. It's the actual receivers that are doing that. So that's what I think I was raising Commissioner Roy previously. All right.
Chair.
Commissioner Roy?
If we could go to the licensing freeze, if you
I
don't
was-
mind. Okay, you're a step ahead of me.
Yes.
You're a step ahead of me.
Yep.
Thank you.
We'll do that. All right. So we're moving on to the cultivation licensing freeze. One of the things I want to clarify, and again, I know that we have motion language, but I got an email today, and I just want to clarify. This is basically new entrants. It's not going to impact moving tiers. If someone wants to move up a tier, this is not going to be, is there a prohibition within this? I don't believe so. I think it's, again, we know that this is a small tool. It's not going to have a huge impact. But if someone is robustly hitting their 100% and they would like to increase, I just want to clarify that is not going to have that impact. Because I did get an email from someone and I said, that is not my understanding, but I just want to, yes, to make that statement, yes. So, Commissioner Roy.
Bear with me 1 second, Madam Chair. Just opening another tab. So I want to thank my colleagues when I brought this up a few months back, and we moved swiftly to hold a public hearing, to listen to stakeholders. And I say resoundingly, I think there were maybe 2 or 3 folks that opposed, but overwhelmingly, stakeholders, folks, licensees were in support of a cultivation freeze. We've even heard through editorials in the Boston Business Journal, the Boston Globe. We all know the significant challenges, price compression being one of them. There's an oversaturation of flower. We have over 4 million approximately square feet of flower, but not even including medical. Already in the pipeline, this is a supply and demand issue. We looked at other jurisdictions to see what they have done to help alleviate this. So the support has been overwhelming in support of this. And so how do we evaluate? And I want to thank our CTIO, Paul Clark, and I want to thank Dr. Sarkis, our director of analytics, who we can't just throw the switch and do a freeze and not evaluate it. And so they took the time to construct very thoughtful metrics on how we evaluate the effectiveness of a cultivation freeze. And so I want to thank them. It's in the board book. Is that public facing? So anyone can look at them to see what those metrics are. I want to thank our legal team. I want attorney AGC Bruno, who got some drafts off the ground for motion language. So I took the liberty to kind of combine them. And I shared that with the executive director. I put that in the chat. And for carve out, I think what makes the most logical sense is a micro business for SEP and EEA. It is the most lucrative, has the most optionality. A tier 1 is a tier 1. But a micro business is a tier 1 with the option of product manufacturer, with the option to get a delivery endorsement, with the option to apply for supplemental social consumption, where the also with the micro business, the application fees are waived, licensing fees are in half. It is by far the most lucrative, and you can scale. Thank you, Commissioner Stebbins and I worked together on that, where you are able to scale. And so it makes the most sense for, if there is a carve out, for it to be for SCP EDA to be micro business. And so I propose that in the motion in the chat. Now Commissioner Benedon and I have check in, and obviously there will be a new board in some fashion, and we want to give them enough of a runway if they want to make adjustments. But the message has been resoundingly clear from licensees and from people who are watching us and watching this industry and watching the folks go out of business and the challenges and the receiverships, that this is not only necessary, it's overdue. This is overdue. So if there are 3 of us inclined to vote in the affirmative, I have proposed motion language where this would become in effect in 60 days. So I don't know if there are any questions or any discussion or deliberation, but when it's appropriate, I'd be more than happy to read.
Please read it so that.
Does anybody have, before
I think it's helpful to read it.
Okay.
Because, so that we have, again, so the public understands what we're talking about.
Okay. And again, thank you, Attorney Bruno. Let's say, move that the commission, pursuant to its authority under Massachusetts General Law, Chapter 94G, Section 4, and 935 CMR 500-100, and based on its assessment of current market conditions and the need to support a stable and sustainable regulated marijuana market, shall temporarily suspend the acceptance of indoor and/or outdoor marijuana cultivator license applications effective June 16th, 2026. This suspension shall not apply to applications already deemed complete as of June 16th, 2026, which shall continue to be processed in accordance with Massachusetts General Law, Chapter 94G, Section 5A, and 935 CMR 500-1022. This suspension shall not apply to micro business license applications submitted by eligible Social Equity Program SCP participants or Economic Empowerment Applicants EEA as defined in 935 CMR 500-002, nor to cultivator operations conducted pursuant to such micro business licenses. The Commission shall review the suspension no later than 90 or 120 days, we have to decide that, after the effective date to determine whether continuation, modification, or termination of the suspension is warranted. Thank you.
Any questions or comments? Commissioner Stebbins?
Do you want to go ahead?
No, go ahead.
Oh, okay. Thank you, Commissioner. I appreciate it. I know you have been doing a lot of work on this. When I had a call with somebody who I regard as, call him a geek.
He was helpful. He was helpful to us.
And he's been helpful to us on some other topics in the past. So apologize. These are questions obviously related to the motion. But this might go back to somewhat the point the chair was raising. So if I have I'm a current cultivator, I think about expanding, but I don't have my application in to move to a different tier by June 16th, 2026. Would I not be allowed to pursue it?
I think that's the point that I was just raising.
Yes.
That it's the same person.
It's the same
It's
person.
the same person. And I think they've already said, no, it doesn't.
But if they're in the queue, I'm just going off the motion. If they're not in the queue yet, that June 16th deadline.
So my understanding is everyone who's already in the queue, they're not impacted by this motion.
No, but but my question was if they are
expansions. Yeah, you said it wouldn't impact anyone that's doing a tier expansion.
That's what I think we all got the same email.
We did from,
Yes,
we did.
Wasn't clear.
Yeah, Yeah.
Commissioner Stebbins.
And if, you, Madam Chair, if I may,
Please, thank you, Commissioner Rea.
so the metrics, if I can take a minute, and again, thank you, Dr. Sarkis. It's the metrics that the commission will be analyzing is supply-demand equilibrium metrics, pricing and economic health, operational utilization, quote, the GHOST canopy metric. Number 4, business viability and attrition. Number 5, inventory velocity. So again, thank you to Dr. Sarkis. So we will be evaluating, monitoring this. We haven't always done that as a commission where we're supposed to be monitoring, but we will be monitoring this as the cultivation freeze in real time. So again, thank you. And I did get that email too, and it would not affect anybody who wants to adjust their canopy, a current licensee.
Thank you, Commissioner Stebbins.
Thank you, Chair. Quick question. We're creating a carve out again for any micro business license applicants or social equity folks. Again, we all want to be supportive. My question is, are we creating a disparate treatment in how we're accepting applications from essentially one group of applicants, but not others in this period?
Commissioner, oh, sorry.
I can, but go ahead.
No, please.
Well, I would say the legislature does similar carve-outs. For the new medical license, they will be exclusive to social equity candidate for, I believe, 2 years. So the legislature has, in its own wisdom, done similar carve-outs as well. I don't know if they're going to say anything similar.
I was going to note as well on that point that where part of the goal of doing this is to really enable us to look at the data and get a handle on it and look at canopy and look at sales. Micro businesses are the smallest tier and would have such a minor impact on that, that even setting aside the preferential consideration of SEP applicants, it seems to me that where our goal is to get a handle on canopy, the addition perhaps of 1 or 2 micro businesses has such a small impact that for that additional reason, I would be comfortable
I agree.
keeping them in.
Director Cobalt?
Just one small clarification where it says, sorry. This is a suspension shall not apply to applications already deemed complete as of June 16, 2026. So we may have a lot of cultivation applicants in the queue. Oh,
Yeah, I was going to ask that too, actually, because that was from Attorney Bruno, and I don't think she's here today. That was language recommended by legal, and that was the question I had too.
So my concern with that is, we may have individuals that have started the application process like 2 years ago and they're working towards getting it deemed complete and might just be.
If I may, so can we wordsmith that like in the queue or in the, so if they're in the queue, they're in the queue.
That are not
They
in
might
the
not be
queue
complete,
by
but they're in the queue.
by June 16, 2026.
So would that suffice in the queue?
Does that, sorry?
Like in other words, we
Submitted.
Submitted an application.
okay. All right, I'll work on that.
Oh, sorry, Commissioner.
While we are wordsmithing, I have one other thought related to the final line. The commission shall review the suspension no later than 90 or 120 days after the effective date. I would rather, I'd be more comfortable flipping that and just having a period of time that this is in effect, such that, let's say this suspension ends in 90 days or 120 days. And this goes back to the point I've raised earlier that we don't know what the board is going to look like. This is a significant policy consideration. In this instance, I do think that this board is best suited to make the decision. We held a hearing. We are the ones that received all the information. We've been engaged with the industry. We have had personal conversations and emails. And so I feel like we know what is needed, but I also am mindful of not making a fairly major policy decision that binds future commissioners. And so I would be more comfortable saying that the suspension shall be in effect for 120 days, after which time it ends, if not affirmatively further extended.
So can I ask you, so is that not placing the burden on them to then go through that process that
it would require whatever board is sitting at that time to decide whether to extend it, and they could just rely on the expertise and judgment of predecessors in doing so. But I would rather that if no action is taken, then it goes back to the status quo rather than requiring an affirmative vote to end it.
I'm okay. Would you mind helping me with wordsmith that last? Okay, thank you.
Mr. Stebbins?
Thank you, Chair. Commissioner, and again, I know this is your item, and you've done an extensive amount of homework on this. And I appreciate the information that was put in there in terms of what data we have the capability to review, as well as kind of what formulas to look at. When you think of lifting the freeze, if we vote to initiate a freeze, what are those kind of benchmarks are we looking for, or the next iteration of commissioners might be looking for to decide whether that suspension continues to be warranted? What
That will be.
is it about?
But I know that our data analytics team, Dr. Sarkis, and CTIO Paul Clark will be ascertaining all of this information. And so we will look to them or the next iteration of the board will be looking to them to inform them in that decision. I mean, it's.
Okay, Mr. Stebbins?
Let's play devil's advocate. If there was going to be no new iteration of this board, if we were sitting here 90 days from now, would you want to be looking at the ability to supply the market? Are we looking at an increasing price as some? And I'm sorry.
If I may,
I'm just trying to think of
I would.
other components of the.
I would stick to the original motion language if we knew this board was in place, but to Commissioner Benedon's point, we don't. And so what she's allowing some breathing room here for the new board to make a decision. If we knew it was us, then I'd say that we would review it on 9120 and then decide. So I hear Commissioner Benedon's point. Let's give the ability for the next board to be able to make that decision based on the metrics established by Dr. Sarkis.
Director Cobble?
Just one quick clarifying question. Would this apply to craft cooperatives as well?
We don't have any. We have one.
Yes.
Stay
all of
alive by June 12th.
Thank you.
Yeah,
I think it
yes,
does.
I think
It does. It
yeah,
does outdoor grows.
Okay,
Yeah, but that's a good question.
But it is a good question, but
Okay.
thank you.
it's kind of fun.
All right. I'm going to adjust. Thank you, Commissioner Benedon. I'm just going to adjust
Thank
it in
you.
the chat. Let me fix this. Give me 1 sec. Oops, I didn't mean to do that. Sorry. Okay.
So, so you've modified this. So, again, incorporating everything that Commissioner Roy stated and replacing the final paragraph with this temporary suspension of acceptance of marijuana cultivator license applications shall remain in effect for 120 days, after which time the suspension shall terminate if not further extended. Do we need to reread the whole thing? Or are we good with that?
Do you think it's best to reread it or?
All right. Commissioner, this is your motion. So do you want to read it? Okay.
That the commission pursuant to its authority under Massachusetts General Law, Chapter 94G, Section 4, and 935 CMR 500-100, based on its assessment of current market conditions and the need to support a stable and sustainable regulated marijuana market, shall temporarily suspend the acceptance of indoor and/or outdoor marijuana cultivator license applications effective June 16th, 2026. This suspension shall not apply to applications already submitted to the commission as of June 16th, 2026, which shall continue to be processed in accordance with Massachusetts General Law, Chapter 94, G, Section 5, subsection A, and 935 CMR 500-102, subsection 2. This suspension shall not apply to micro business license applications submitted by eligible social equity program SCP participants or economic empowerment applicants EEA as defined in 935 CMR 500-002, nor to cultivator operations conducted pursuant to such micro business licenses. This temporary suspension of acceptance of marijuana cultivator license applications shall remain in effect for 120 days, after which time the suspension shall terminate if not further extended. Thank you.
Thank you.
So moved.
So moved. Do I hear a second? Commissioner Stebbins?
Second for the purposes of voting.
Having been moved and seconded, I'll call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins,
No.
Commissioner O'Brien votes yes. It passes 3-1. Thank you. Thank you very much, and everybody. Thank you for your work on this.
Thank you.
I do want to, and we will get to, the cultivation freeze, means the red tape removal working group, and manager of government affairs and policy, Attorney Jessica Porter will be joining us. And I want to thank you all because I've learned so much and I appreciate it. And again, sorry we couldn't take another hat off of you, but anyway, I really appreciate all the hard work and all the feedback. It's really been a pleasure. Thank you very much. Thank you. And thank you for taking the tough questions because you always do, and you always do it with a smile. And I want you to know it does not go unnoticed. Thank you.
My pleasure. Thank you. Thank you.
Oh, Jessica, you have done. By the way, all right, can I just point out, all right? Commissioner Benedon is a math whiz, and we noticed her on the fly, and apparently she is also a math team competitive coach. But I want to point out.
Fourth grader.
that
Fourth
Jessica-
graders, fourth graders.
But still, that, the new math is hard.
Attorney Proctor, the math that you have done, had no idea you were going to do this. And I haven't had a chance to really applaud and thank you for this because
Incredible.
I know, but it's like my mother, actually went and took quote math. She took a course. She'd been a school teacher in the Roxbury schools when I was born and wanted to be able to help me and literally took a course at Hawaii Community College. I never, even though I was the state treasurer, I could never do math. I just hired really smart people who could. But I got to tell you, the work that you've done, incredible, put this together. But more importantly, the vetting and the numbers, it was extremely helpful. So I want to applaud you and I want to really thank you for that because it was a ton of work. So I will turn it over to you now, but thank you very much.
Thank you, Chair, and thank you to the internal working group who helped with all that math. So we can go to the next slide, please. The red tape removal working group began in December, as you all know, with the purpose of reviewing commission regulations and policies to find opportunities to streamline red tape where appropriate. The external working group members, some of them were announced in public meeting, were selected to participate by you, the chair, and Commissioner Roy based on their license type, the organizations, to make sure that we got a variety of stakeholders. Next slide, please. These are all the members who were part of the external working group. I'd like to thank all of them for their insight and recommendations, and also a special thank you to the internal staff who were on the working group, who did this in addition to their existing priorities and workloads.
And I'm going to just quickly read their names because we just gotten so much great support. Ryan Dominguez, Kevin Gilner, Dave O'Brien, Megan Drogo, Chris Godala, Caroline Frankel, Nike John, Victor Chang, Meg Sanders, Jeffrey Harold, Armani White, Devin Alexander, Chris Fevry, Alyssa Nowak, Ulysses Youngblood, John Napoli, Dominic Schelsey, Matt Allen, Cheryl McGuire, John Pizecki, Angela Brown, Kristen Rogers, Brian Adams, Matt Gamble, Steve Riley, Ed Dowd, Dave Noble, Jennifer Keeley, and Rob DeFazio. And there are many more people who provide us with feedback, but I just wanted to say those names because that was very helpful.
Absolutely, and all of their participation throughout all the phases of this was huge. Next slide, please.
So I'm going very briefly over all the work that the working group did because there's a 14-page report in the public packet and we don't have time to read a 14-page report in this. But basically, I want to draw attention to the fact that it was a 4-phased process to review recommendations. So we were able to combine recommendations, we were able to score them, we were able to actually prioritize them as well. And that's what we're going to be talking about today. The average scores were broken into 4 groups, so everyone had a chance to rank them. We received a total of 21 respondents from the external working group on the prioritization phase. For the collection of recommendations, we received a comment from at least every single member, part of the external working group and part of the internal team as well as other departments who submitted them to internal working group members. So with these 4 tiers, it was a basis on the average of scores. So on the next slide, we will talk about the high consensus items. So these 5 items were the highest consensus among the external working group respondents. We kept the internal list separate, as we know stakeholders externally have different priorities than internal staff as well, as it's affecting their business day to day. Internally, we view it through a different lens. The external stakeholders place particular emphasis on operational efficiency, responsible vendor training. As you can see, there were 2 items associated with that. One with advertising, which some of it is taken care of with the bill, and fee structures, inspection flexibility, and reducing prescriptive requirements that increase costs on their end. So during the in-person phase 2 meeting, we also took an internal unofficial poll to gauge interest in adjusting the annual license renewal process to be biennial every 2 years instead of every year. And the group voted unanimously in favor of this change as well. So these recommendations, again, there's 84 of them total, all prioritized in different categories. They have not been reviewed by internal staff to see if they're legally sound or if they have a issue with public health, safety, if they're equitable, anything like that. This is just for the external team prioritizing them, and the internal team recommendations are also in the report as well. Again, want to thank everyone who participated. This was a lot of work and a lot of team effort on this and creating this final report as well.
Thank you very much. And obviously this is just teeing things up. It's going to be a lot of work to still get done, but I thank you so much for doing this, and I think it clarifies and it helps us. I think I used the term 3 years ago, low-hanging fruit, when I initially wanted to remove the 2-driver rule. Unfortunately, it took another year to get that done, and I'm hoping that the momentum of this work will continue because the industry can't wait. So again, thank you. Commissioner Roy, you're raising it? Oh, I thought you were raising it. Commissioner Stebbins?
Sure. Thank you, Chair. Thank you, Jessica, for doing the math, as it was pointed out. Also want to thank my 2 colleagues for organizing this committee and getting some tremendous work done with a broad array of stakeholders. Just want to offer some reflections on the high consensus recommendations. Chair, you and I have talked about responsible vendor training and blowing that up and starting all over again. I'm reminded of, hopefully using, maybe even the commission taking on some of that responsible vendor training program so we can keep licensees compliant and ever informed about changes to regulations and what we're looking for. The other one that popped up, and I don't know if Director Enos is still in the room, but love to dive into a little bit more, is one that I know we've all heard about, and it's why it's on this list, which is allow deficiencies to be corrected during inspections. So quickly, I've been on tours. Actually, was one on a tour in Holyoke when the investigative team showed up. We always get the question, why do 5 or 6 people descend on us? I think you've explained it previously that it helps us get through the process quicker. Hopefully it takes up less time for our licensees. But this question around, if you're going to hit me on a deficiency that I don't have, like an authorized personnel sign it, and I have one and I can put it up, getting back to our concern about what can we take off your plate, what can we hopefully expedite for our licensees. Because you're usually on site with more than 2 people, if I got the sign in back, can I go put it on the door? Still acknowledge in our records that you had to get dinged for it, so in case you show up the next time and it's not there, you get somebody to ding again. But if I can correct it on site, there's still a record of it. And then it saves the notice of deficiency timeline, the plan of correction timeline. Is that something you and your team have been thinking about? And is this recommendation, which is in that high consensus recommendation, something that you all could figure out? Would it require a reg change, or is it just, it might involve a reg change because I know the dates and times are built into the reg change, but what would be your thoughts on that?
Please.
Recommendation.
Please, thank you.
Thank you, Madam Chair. Thank you, Commissioner Stebbins. I absolutely think, and obviously we'd have to kind of talk with our team and kind of, put our heads together there, but kind of speaking generally, I absolutely think there are some violations that absolutely would be suitable to be fixed on site. So I think your example again of the limited access area signage, again, if a licensee has an extra sign, it just hasn't been put up, that is absolutely something they could fix in a moment. I think kind of historically where our staff not has been hung up, but obviously the regs require for notices of deficiency that if we see a violation, we obviously have to report it, we have to document it. And again, NOD serves also kind of informational, educational tools to licensees. So in that instance, our staff would still have to take the time likely to draw up that NOD. But if the licensee wants to get ahead of that and the corrective action has already been completed, then I think that would then save licensees time on the plan of correction. Now, again, there are varying levels of different violations. Some are easy to fix, some aren't, some would require some time, some won't. But I think in the example that you raised, Commissioner Stebbins, that's absolutely something I think we could cut down time with. Again, our staff would still have to go through the exercise of drafting the NOD, submitting the NOD. We would still expect that written plan of correction back. But if the licensee could get a jump and already correct everything, then that's just the actual creation of the document. I absolutely think there is room for that. But we certainly would need time, to your point, to kind of go through just the varying kind of degrees of violations we have. But there absolutely, I think, is space for us to consider that.
Okay. Thank you.
And again, thank you, Attorney Porter, to the whole working group. You can see how much time, effort, and energy went into this. And we just touched on the strongest consensus ones today, but there are 84 items on this list for red tape. Now, some of them, I think we kind of said, not so much on a few of them that day we were here, but some of them do have strong merit. And so, and I've been working with Commissioner Stebbins on the biennial renewal. We have it in a pretty good place. So I think that could be sooner rather than later for the next board to tackle. But there are some of these that absolutely deserve consideration in this list of 84 recommendations. And so, I guess for today, we're passing the baton, if you will. And, hopefully this work will continue. There has been so much collective enthusiasm about this, the red tape removal. And my sincerest wish that the momentum keeps going with this. And, the RVT, I think we came up with, we could do a shall to a may on the RVT till we're able to freshen it up, so to speak. And, it makes sense. Maybe it's the new initial hires that take it. And so there's room there and a lot of work to do. But I'm grateful to everyone, Chair, that you read and everybody that participated in this. And it's my sincerest hope that this red tape removal keeps going at a robust pace. So thank you.
The industry can't wait.
No, they can't.
Yeah. Commissioner Stebbins.
Thank you. Just a quick question for my two colleagues. Were there recommendations that were new to you or jumped off the page?
Yeah, I think the positive impact plan one was, because again, I've said this, it was well intended, but alcohol industry doesn't have positive impact plans. And what's happening is it's becoming a lot of red tape. And I think there's a way that we can make it quality impact plans that positively impact people. I think there's a way to streamline it. And so that was newer. And, obviously, badging is, and I know that's had your attention with badging. I think people would like to see the badge follow the employee. I think there's a lot of things we could tie that into our equity career hub. Along with a positive impact plan, it could be when you need a butt tender, you need to post on that equity career, equity
By the
work.
way, We had not mentioned Equity Career Hub yet today.
Yes,
thank you very
you're
much. This
welcome.
is like,
Career-
drinking game.
Yeah,
Thank you very much.
yeah.
You did it. Thank
So, yeah, a few of them did stand out, and again, there's 80 some odd on the list, and I think some are absolutely worthy to remove that red tape.
And one of the points I would like to raise is a number, especially when it comes to positive impact plans, a number of social equity applicants are almost the most frustrated by this because they literally are working positive impact businesses. And so, you know, and so that additional paperwork and work that they have to do, you know, again, you know, it's making sure that we are getting rid of unnecessary red tape, focusing on public health and safety, taking a few hats off of the folks who are wearing multiple hats and doing more than one job. So again, I appreciate the work that everyone has done. Again, because I don't think we're going to be able to vote on this today. So it really is just thank you very much. Commissioner Benedon, if you have any comments before we can move on.
Yeah, I just want to reiterate that this is incredible. This really should serve as a roadmap for the work. There's so much that we need to do in other ways, but in terms of things that can be done on more of, I guess what I'll say is discretionary basis, even though some of these things don't seem that discretionary and that they seem so critical. But in terms of providing some direction, I think that this is so critical. One thing that I noticed, and I don't think there's anything to take from it today, but there are some areas where there really was a fair degree of consensus between the external stakeholders and internal, and somewhere they're pretty disparate.
Right.
And that's something that I found very interesting. And I'm sure some of that is that internally we are thinking about what is necessary for us in terms of streamlining workflow and increasing capacity, and that it does not always align with the industry. And so I think that's something that we really will need to balance and focus on. And you know, what do we prioritize when something might be high consensus for the industry and then all the way down to categories at moderate for staff? How do we think about that? But the way that it's laid out just makes it so clear. So we will have to grapple with that question, but it's clear what it is.
Thank you. Okay, thank you very much. And again, my applause, and only because, and again, you know, my apologies. I need to unfortunately drive to Boston, and so I want to sort of tie up a lot of loose ends here. I want to especially thank Anne Reed-Burt and Fiona and the rest of the team that have put together the campaign for 420. I direct people to go to our website, thanking Anne Reed-Burt and the team. They've really done a fabulous job. This is public education, making sure that people enjoy, you know, what is the high holiday, if you will, to enjoy it responsibly. So all of these videos will be on our website. Again, you know, my apologies because we've just had so much substantive work to get done today. So again, I thank the team, I acknowledge their work, and I direct people, and we will be putting out, you know, things on our Instagram and our X or Twitter or whatever we call it anymore. We will be putting that all out there. But again, I thank the team for the work that they've done on that. Just quickly, just asking the executive director, just a real quick update. Just thinking, I'm just making sure I'm not missing anything here. We've gotten through all of the commission votes.
Madam Chair, I'll just review what's in the packet and not go through it. Does that work? Okay, great. So just a couple quick notes. Deadline today, 5 p.m. to get feedback into the form stack on the testing protocols. We've got a lot of feedback already, so that'll be collated, but still some time here. Wanted to note as well, it did just come up, but the Equity Works Career Hub designed year-round hiring and workforce development platform supporting the Commonwealth's legal cannabis industry will host its first virtual cannabis career fair on May 20th, 2026 from 10 a.m. to 4 p.m. That information is also in the slide deck in the packet. In the packet, you'll find also the first of what would be the consistent ED report updates on the progress of the social consumption working groups, which was put together by Juliana in the project management team. So that is in that packet if anybody's interested for an update on social consumption. 420 awareness campaign, as the chair just mentioned, is information there, and a press release will be coming as well. Videos and links will be available. Lastly, just as we always do on the licensing update, want to note that those slides that are consistently in there and some updates on those slides that were requested previously are in the public facing packet. And then just two notes, just for people's awareness, we have had a couple folks voice concern about potential licensing if this bill goes into effect, if their date is after today. And obviously the commissioners got through quite a bit of licensing today. The licensing team will work with anybody on any sort of short-term impacts. That we don't believe that anybody will be negatively impacted looking ahead at dates, but the licensing team is here to make sure that nobody feels like they may be impacted by a potential bill or transition period. And additionally, we've had a couple folks note the medical use or as.
So just telling people will be able to call in. I mean, how do we want, I mean, obviously, what's the email that people should be using if they have any questions around, who do they send an email to?
The licensing staff that they would normally be working with will be on top of anybody who's in an interim period, and will.
What I'm saying is you who are not, you know, maybe they're about to be in the queue, you know what I mean? Like we're doing a couple of different things right now. We're doing the changes that we're making right now. So what is a
Licensing at cccmass.com. Absolutely. Yep.
Again, licensing at cccmass.com. Just if anybody has any particular questions about, you know, any of the votes that we've taken today, what's going on with the bill or the law. So in I'm just trying, any other places that people should be reaching out or asking questions?
Yes, Madam Chair. So just one other item. So anybody concerned on the medical side, the medical use of marijuana program will continue to register and renew patients and caregivers without interruption. Certifying healthcare providers will continue to issue certifications. And if anybody has any questions, they reach out 833-869-6820 or commission@cccmass.com. 833-869-6820 or commission@cccmass.com would be the other option. Thank you.
Anything else? I mean, obviously, you know, we don't know what's going to happen. I wanted to make sure we were getting, and again, you know, if people would like to continue having conversations and if there are any, I did not have opening comments, so I don't know if anybody has anything that they would like to add at this point. Commissioner Bennett.
Could I have like 45 seconds?
Wait, oh no, I'm just saying, I know
we have some.
Again, sometimes we all have, I don't have a hard stop, but I have to drive into Boston. I don't want to kill anybody, so just want to.
Sure.
Please
so
go ahead.
We do usually have that time at the beginning, and during that time, usually what I do and what others do is just report on what we've been working on, external meetings that we've had, acknowledging the incredible work of the staff, which there is never enough time to do. But I do just want to use this opportunity, given that this could be our last public meeting with this makeup of commissioners, and I want to thank my fellow commissioners. That's something that I think I don't do often enough. Madam Chair, Commissioner Stebbins and Commissioner Roy, you welcomed me when I was appointed 5 months ago. You've mentored me. You've been open to my ideas. You've shown respect for my ideas, even when I've been a stickler about the open meeting law. And it's really just been a privilege to work alongside all of you. We all come from different backgrounds. We have different priorities. We have different work styles. We've disagreed, but I think we've done it respectfully. We've been productive, we've been collegial, and I think we've accomplished a lot. So I really, and we truly don't get a chance to talk outside of meetings. One-on-one, we can talk, but not about the same thing. And so I just wanted to use this public forum to say thank you to my colleagues, because it's really been a great experience.
Thank you. And thank you. And I would be very happy to violate open meeting law to say thank you. So thank you very much. Commissioner Roy, do you have any?
Yeah, I'll be very short, and you know, just to echo on Commissioner Benedon, it's been a real honor to serve with all of you. Truly, this has been an experience of a lifetime. I'm proud of the work we've done together, and I think we've got a lot accomplished. And, you know, I want to thank the executive director. I want to thank the incredible staff. It's been a real honor for me to work with all of you. I hope to continue in some capacity in this space, and proud of the work we've done together. And we've done so much together. And just keep moving ahead. Let's just keep the momentum going. There's so much work to do. And everybody works so hard and wears so many hats. And again, thank you. And thank you to all of you. It's been a real honor for me.
Commissioner Stebbins?
Thank you, Chair. I wanted to give one quick update, which I think is helpful. I had a chance to mention this to Danny Carson when he was here earlier. The Chief of Staff and I had a chance to talk with a great guy by the name of Michael Fiore. He is a program supervisor of the state's Safety Works program under the Executive Office of Labor and Workforce Development. They offered free consultation services to small businesses, which I'm assuming most of our licensees would qualify for. They come in, do a free confidential assessment of workplace and health safety issues. They will provide that service, again, free of cost. It's all all confidential. If a licensee has union representation, a union rep is allowed to join and be part of that process. So hopefully encourage the ED and perhaps our comms team to reach out to Michael and provide information on his program so our licensees have the chance to take advantage of that. Finally, I'll echo my colleagues. I feel it appropriate to express thanks to all my current colleagues. It's been a pleasure to work with all of you. And even express my thanks to our former members of the commission, both previous commissioners and staff, who helped build the regulatory foundations for this industry. Some folks have obviously moved on to other careers and other opportunities, but I think everybody contributed something to the foundation for this industry. And though it oftentimes has not always gone smoothly, that's expected to be the case for organizations, especially new ones who are chartered to do new things with a new industry. But greatly appreciate the opportunity to work with all of you, and thanks.
Thank you. And again, echoing, I also want to thank the staff. And I think that in particular, just noting what Commissioner Benanon said, that we can often disagree and be very robust. And I think I especially pointed out to the folks in licensing and enforcement, we've been particularly pointed in getting them to do a number of very, very difficult things. We've gotten a lot accomplished. Obviously, my tenure here was briefly interrupted, but I'm especially thankful for all the people over the course of the last, 7-8 months that I've been back here. I think that this has probably been one of the most productive stretches of time that we've had at the commission, short of the initial group of commissioners who had to stand up this industry. So I'm very grateful to all of my fellow commissioners, to the executive director. But again, thanking you all very, very much. This has not always been easy, but it's been wonderful to be a public servant. And one of the things I will say that regardless of what happens in the future, one of my goals is to establish a Center for Cannabis Research Excellence. So that will be something that either in the future working with the commission or also working with outside persons to make that a reality. So that is something we didn't talk about today, but it's something that's important again. So right now we are technically scheduled to meet on April 30th at 10 o'clock in the morning. And so I will entertain a motion to adjourn until April 30th at 10 o'clock. Do I hear a motion, Commissioner Roy?
So moved.
Do I hear a second, Commissioner Stebbins?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Benedon.
Aye.
Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. Somebody will be here April 30th.
Meeting adjourned.
All right, thank you very much.